Serial number 7, PS Chapanari, the next public post. Wait, please. Yes.
As I am seeking your lordship's indulgence to press a 389 for suspension of conviction.
Yes.
And let me give your lordship the 6 broad heads on which I seek that. And then I'll take them point by point on those 6 broad heads. Well, as I respectfully seek a stay of suspension, a stay of conviction,
Yes.
or a suspension of conviction. Firstly, because, Balas, on the very tests propounded in as many as 6-7 pages in the beginning of the Sessions Court judgment under appeal, under revision, the offense involved here is admittedly, and I use the word admittedly, on the basis of the 6 pages of judgments extracted by the learned Sessions Court, neither of a serious nature nor of moral turpitude, which are the 2 tests your lordship applies to deny, if at all, in an relevant case, the suspension of conviction. So that is going to be the first head, which I will show to your lordships. The second head, Balas, is to take the allegedly offending sentence or words and show that they do not relate to or invoke or inculpate any identifiable, suable class of persons. Well, if you make a statement like this, you cannot have anybody out of allegedly, not as per us, as per the complainant, 13 crore people, anyone can be a complainant. That is not the law. There is no such identifiable, suable class to at all maintain a complaint. So jurisdictionally, the complaint would not be maintainable is going to be my second set of submissions.
But that will decide in the appeal.
No, but these are all under 389.
389 only we have to see the suspension, why the court has not suspended this.
Correct. Now, one of the tests of your lordships for suspension,
Yes.
one of the tests of your lordship for suspension is that a prima facie case, a very
Since your
strong
main
case.
appeal is pending before the consent trial.
Well, that will always be the
First
case in
appellate
389. Correct.
Yes.
So your
Now
lordships,
only 389 is, and against
Correct.
that order you are preparing the revision application.
my lord is right.
So we have to see just 389 only.
Well, only 2 things. In
We cannot
389,
go into the main proceedings, which is pending before the lower appellate court.
with one caveat, with great respect.
Hmm.
Under 389 now,
Yes.
under 389,
Hmm.
your lordships will grant suspension of conviction on the
circumstance?
basis of prima facie case,
In
one.
which circumstance?
First is
Yes.
on a strong prima facie case.
Yes.
That's your lordship's first test.
Therefore, the learned first appellate court has considered your request and granted the bail.
That's on, but that's on sentence. I'm now talking of suspension of conviction only. Conviction. Under 389,
Yes.
apropos my lord's query,
Yes.
that the main appeal is pending,
Hmm.
and what test should I apply
Hmm.
for a 389 suspension of conviction? My respectful response is number 1.
Yes.
The first test for stay of conviction under 389, which will always involve the main appeal pending. Well, unless the main appeal is pending, I'll never come in a 389 to your lordships. The first test is prima facie strong case. Why is that test given? The test is given because tomorrow, Mullahs, I win my appeal. In the meanwhile, very serious adverse consequences flow, which are irreversible. So a lordship sees that is there intrinsic strength in my case. And for that, Mullahs, the ground that the very complaint could not be filed on the basis of a non-identifiable, non-suable class will be directly relevant.
Exactly.
That's the second head, Balas. Because if a complaint could not be filed on the basis of a non-identifiable, non-suable class, in this law, your lordship doesn't allow anybody to walk in. This is one of those clear exceptions to criminal law, as your lordship knows, your lordship is handling the criminal roster, Balas, that people can, in many, many offences, anybody can complain, or largely anybody can complain. This is one of the rare exceptions in the IPC and CRPC, which say that only a person with locus can complain, and that locus cannot be eliminated by saying that anybody of a non-identifiable massive class, group of people will constitute a complaint. That's my second head. My third head is that there are about 4 or 5 very serious ex facie, I mean, we are not asking for lordship to examine the merits, ex facie on the face of it, vitiating factors of the trial on the face of it, which raise grave apprehensions about the process of trial which led to my conviction and which are bound to succeed in my appeal, and therefore today make out a very strong prima facie case. So in prima facie case, both these last 2 points will apply. Yes. Serious vitiating factors of the trial. My fourth is, Balas, to separate one of those vitiating factors, namely 202, and deal with it separately, because for 202, which your Lordship's Balas inaugurated as a special amendment, as a special dispensation, was intended to protect from frivolous, hasty prosecutions, precisely such situations. And here, Balas, no satisfactory answer is given to your Lordships, either by the learned magistrate or by the learned sessions court, as to how 202 has virtually not been dealt with except one point, that it was raised late. Your Lordship has held repeatedly, A, it is mandatory. B, if it is mandatory, Malas, it has to be a jurisdictional point. Suppose I didn't raise it at all. Even then, Malas, the judge has to apply his mind and do the inquiry. For example, Malas, limitation, to take a civil law analogy. Civil law analogy, Malas, he may not raise limitation. But if your Lordship, Malas, is bound to it, your Lordship will see, and your Lordship can suo motu and should suo motu take it up and dismiss or allow. That's the Malas, fourth aspect. The fifth aspect is, Balas, that, and this is quite astonishing, Balas, the offending sentence or offending speech, absolutely no documentary evidence or no evidence, forget the word documentary, Balas, no evidence in terms of the law, in terms of the Evidence Act, in terms of the IT Act, has been produced to justify at this stage proceeding even to a conviction, Balas. To just digress for 30 seconds, Balas.
Yes.
Your Lordships in a speech will have broadly three possibilities. Either I am the complainant, I have myself heard him saying this, so I am the witness, I depose. The second is I was not there, but Balas, my learned friend there is a reporter or a journalist who has seen it, heard it and reported it. He can depose. A third is, Balas, neither me nor reporter, but Balas, a direct person who can authenticate it. Here your Lordship will find that none of the three apply. Therefore, under the IT Act and under the Evidence Act, there is absolutely no proof of the offending sentence ever being uttered. Without that proof, a conviction can't lie, per se. Then, a very, very important last point would be the irreparable, irreversible nature of the consequences. Why is, at the end of the day, 389 made? 389 is made because your Lordships have certain, and in this case more than any, extraordinary consequences of conviction. Now, anyway, conviction has bad consequences. I mean, one can't travel, one can't do this, that. But in the case of a public servant or a legislator, be it parliament or, it has very serious additional consequences because, such a person, suppose he misses representing his constituency
then
for some time.
More impact duty towards the public at large. He is representing the people at large.
Yes.
He has to make his statement within limits and within bounds.
No, therefore, there is no additional liability for a public servant. Suppose, a public servant makes a statement. Let me put it like this, apropos my Lord's query. Suppose, otherwise,
yes,
he is a not public servant, I am a public servant. Otherwise, your Lordship find that this is not defamation. Your Lordship will not make it defamation because I am a public servant. That's not the law. The law is not that on the face of it, the offense is not defamation, but because a public servant has done it, therefore it becomes defamation. But that is not the point I am making, Manas. The point I am making is that when your Lordships gives or does not give 389 suspension of conviction, my Lord looks at irreversible special consequences. There is not that consequence for an ordinary person. Today, Malas, it has a consequence on myself. I stop representing. Suppose, Malas, I have missed, actually in this case, I have missed 15 days of the last session.
yes,
I may miss the next session completely. So that's a consequence to yourself.
yes,
The second consequence is to the constituency you represent. That constituency, the collectivity of that constituency is deprived of your representation. Third, it leads to the drastic consequence of a re-election. which makes, suppose I win my appeal after re-election is announced. How does anybody, including a court, reverse it? Can't be reversed. It's irreversible. Your lordships, have done exercise of 389, where the admitted test is, it has to be a concurrent stay of conviction and a concurrent stay of sentence. Now, your lordships have, and I'll start with that point, done that exercise for very serious cases.
Yes.
Mine is a case which is neither serious nor moral turpitude. Therefore, if for sure I am entitled to that, so let me start with that first point.
Yes.
Therefore, my first point is, please note these cases,
Yes.
and the lordship will see the consequences. In para 5 of the Sessions Court order, which is impugned, a case cited is Shyam Narayan Pandey. Your lordship will see para 5. The case cited at page 63, it is cited, lordship need not read it, just note it at 63, it is there,
Yes.
which is a Sessions. Now, the point I am making as my first point, this is my first point, 1A, lordship may call it, that the learned Sessions Court relies on these cases to deny me stay of conviction,
Yes.
to deny me. My submission is that the very same cases he relies on operate in my favor, because the test in the first 6 pages of this order your lordship is holding is that cases of seriousness and moral turpitude I should deny or should be denied. But by contrast, defamation with a maximum sentence imposed does not fall into that category.
Yes.
So what was the first case which is mentioned in para 5 minutes?
Yes.
That case is a case of life sentence, admittedly. Please note that it's a case of life sentence.
Yes.
Therefore, that case is a wrongful, inapposite, incorrect citation by the learned Sessions Court to deny me bail. You are actually, by contrast, making out my case. By contrast, I am not a life sentence case. I am a non-cognizable, bailable offence case. Then why do you cite this judgment? Error number 1. Error number 2, the other judgment is at page 61, para C, Navjot Sidhu.
Yes.
Navjot Sidhu was what, it was a case of 302 murder, then ultimately found in 307.
Exactly.
Again, you are citing it to make the point that your case, that is the today's case, is serious enough where here this should be denied and your case therefore should be denied. So the first point is that again, is an inapposite, incorrect. By contrast, I am entitled to it. In fact, it's very interesting. Sidhu with a 302 and 37 charge also got stay of conviction. He got stay of conviction. The third case, cited the third case also known as Ravi Kant.
Yes.
Ravi Kant is cited at para D, T for Delhi at page 61.
Yes.
Well, it is extraordinary. It was a 376 rape case and a 366 abduction case. So the test of seriousness applies in the reverse in my favor. You are citing rape, murder, abduction cases. So you are applying elephants to mice. Not apples to oranges, you are applying elephants to mice. The fourth case was cited at page 62, para E for England,
Yes.
is Dattatreya.
What is the conviction imposed by the trial court in Dattatrey's case?
Prevention of Corruption Act.
But what is the conviction period? It is for?
No, your lordship has said there are two kinds. That's why I'm your lordships have said that either it's a serious case, which is life and 10 years,
But then they
or if it is less.
They state that it is in rarest of the rare case only to be considered, the 389.
Well, kindly see.
Yes.
Where the offense, the punishment is less, then you can still be denied for a different test, moral turpitude. That's there are two tests.
Considered in this.
That is considered in Kumbat. Kumbat was a PC case.
Yes.
So PC falls under moral turpitude. PC case falls under, so I'm saying, well, one is a case of murder or serious long offense, a long punishment. The other is a case of moral turpitude. I'm neither. I'm neither. So by contrast,
But then in that judgment, paragraph 26, 27, and then paragraph 111.
yes,
The Honorable Trial Court has considered Honorable Apex Court guidelines.
so therefore I'm showing lots of guidelines, but kindly see, the guidelines are only these two.
Yes.
Serious offense, long sentence is one guideline. The other is moral turpitude. That is why your lordship should really be seeing each of these cases by name of the nature of the offense. There's no other guideline. The principal guideline, lordship will just note, the guideline in Shyam Narayan Pandey, the main case,
Yes.
in Malus para 6
6.
is serious or moral turpitude. I am adopting the guideline which is followed from my lord just now. Under that guideline, I am dealing with one by one all cases. Each case is either a serious case or a moral turpitude case.
Yes.
Where is the case where your lordship has denied 389 for neither a serious case nor a moral turpitude case? There's no case like that. Now, on the contrary, 302 you have allowed conviction stay with the 302 case in Navjot Sidhu. You allowed it. So, on all these three tests, I am entitled to the reverse benefit, not culpability. Now let us see, Gajanan's case is again a PC Act case. That is not cited in the Sessions Court. I'm just giving it.
Yes.
It's again a PC Act case.
Yes.
Narang, cited in para A, page 59,
Yes.
is again a PC Act case, 5.5 years given. Rarest of rare is that you can grant even in a serious case, even in a moral turpitude case. If for sure your lordship is not going to apply the rarest of rare case to a case admittedly non-serious and admittedly non-moral turpitude, that would be turning the law on its head. So that's the first point. And then one very important case cited is KC Sareen. KC Sareen again is PC Act, page 60, para B.
Yes.
Page 60, para B. So, I have given your lordship 7 examples. The learned Sessions Court starts his judgment over 6 pages by citing, and your lordship will just give me a minute on page 63 minutes. Can you turn to 63?
I'm on 60.
That rarest of rare which my lords formulated just now from Pandey is for, directly at page 63, para 6, it is there, is for serious cases also. There is no bar to a 389. It is not that your lordship says that a serious case of murder I'll never give. Even there you will give and can give, but you will give it more sparingly, quite rightly. Therefore, I am clearly a fortiori case. It is undoubted that I am a fortiori because nobody can suggest that I fall in the moral turpitude class or a serious class. In fact, a non-cognizable, bailable offense, which is not against society at large, is the third important point. The idea of your lordship's approach in this is that there are offenses against society at large. Otherwise, why does your lordship have this provision that a person directly defamed can alone maintain a complaint? Your lordship has that. For a murder, it is not that only the victim's family can file. This is the difference your lordship makes, because your lordship says that in such matters, it can't be called serious or moral turpitude if it is not a societal or anti-societal offense. Therefore, I find no reason in the first 7 pages. It's an error of law. Yes. It appears to be a clear error by the learned court below by applying 6 pages of judgments which apply in the reverse in my favor. Now just see the quotation at 63. And these are not quotations, they are underlined by the judge, as the lordship has noticed. So that obviously the basis of his judgment is these underlinings. Now just see one of them. It has been consistently held by this court, unless there are exceptional circumstances, the court shall not stay the conviction, though the sentence may be suspended. There is no harm. Now this means that you shall not stay in serious cases, because the next para makes it clear. Otherwise, what your lordship would be told is that you will not stay conviction in let's forget this case for a minute. Let's take a case of I can't give an example. Take a 1-year offense case, anything. The most trivial offense, bailable. Well, if the test of 389 is that in a 1 year bailable, non-cognizable, non-societal offence, your lordships will rarest of rare case suspend 389. That will be turning this on its head, Wallace. Now see, Wallace, this Law Commission is referred to in para 6. See the next line. It was regarding the release on bail of a convict where sentence is of death or life or not less than 10 years. If the appellate court is inclined to consider release of a convict of such offences, the public prosecutor has to be given an opportunity for showing cause in writing against such release. This is also an indication. I am reading this for Lordship. This is also an indication as to the seriousness of such offences and circumspection which the court should have while passing the order of stay of conviction. Just pause here. What is, Wallace? This is also an indication as to the seriousness of such offences. Certainly, if I come with a serious offence to your lordships of 302, I can still ask that these circumstances, but your lordship will say, I'll consider it's a serious offence, I'll do it sparingly. Your lordship will not apply the rarest test where the offence is not serious. That is the only meaning of this sentence, which can be. Similar is the case where this is category 2. There may be, seriousness is defined one way by the length of sentence. Now, there may be moral turpitude cases with less period of sentence. So, the court takes care to put that category. Admittedly, I am using the word admittedly, non-cognizable and bailable offences fall in the neither category, clearly. Similar is the case with offences involving moral turpitude, and prevention of corruption is the best example. If the convict is involved in crimes which are so outrageous and yet beyond suspension of sentence, if the conviction also is stayed, it would have serious impact on the public perception on the integrity of the institution. Such orders definitely will shake the public confidence in judiciary. That is why it has been cautioned time and again that the court should be very wary in staying the conviction, especially in the types of cases referred to above. And it shall be done only in very rare and exceptional circumstances of irreparable injury. This whole para, where the last line, the suffix is underlined, relates to the previous part, serious and moral turpitude. So that's the tribals. Therefore, this is the first important point. This applies, by the way, right from the beginning of the judgment till where he finishes, citing the cases, which is all these pages you should have seen, virtually from the first page, on to about the 7th or 8th page. He has given about 6-7 cases. Learned judges underlined them, but with great respect, this is a patent error. The cases which you have relied upon and underlined are themselves the cases with the greatest of respect and humility you have misunderstood and misapplied. Now, here, if I may digress for 2 minutes and ask your lordships to come to a chart, which will give your lordship an idea of how much more serious offences. Now, this is, before I read it, I must preface by cases where disqualification and conviction intersect, namely cases relating to MPs, MLAs, where offences far more serious have led to a stay of conviction. Now, I'm giving you that chart in a minute. Kindly turn to that chart, fellows, at page 685. Same volume.
Yes.
Now, if your lordship will see, lordship may do me the favor first of marking on the side in each of these, then I'll elaborate it. It will make it easier for your lordship. So, lordship does.
Yes.
The first is a PC case. Just your lordship will write PC on the side. So, lordship makes it easier for your lordship. The second one is a PC case. Mohammed. The third one is also called Mohammed Lakshmadeep. This is interesting, the High Court has granted stay and I am appearing in the Supreme Court for the person who has a stay. The state is in appeal. This third one, which is also another Mohammed, Sayyid Mohammed from Lakshmadeep, it is currently going on in the Supreme Court, is a 307. Actually, the allegation is 302, but the conviction is 307.
It is under IPC.
And mind you, every case I am giving here is a stay of conviction. Stay of conviction. In this, the third case your lordship is holding just now,
yes,
the High Court gave a stay of conviction. Matter went to Supreme Court by the complainant and by the state. It is pending. I am arguing it for the respondent. The learned court number 3, Justice Joseph, has not given a stay of the stay granted by the High Court. It's going on right now, Malas, and is being listed every. Now, all these are MPMLAs, all these are conviction cases, all these are stay of conviction sought, all these are disqualification consequences, all of them.
Yes.
So, Malas, is very clear that, Malas, to suggest, and that is the error I say with great respect of both Malas, in particular the Sessions Court, that as if 389,
Yes.
Malas, also kindly consider, apropos what my Lord said, I'm very grateful for that. Your Lordship is not here to, Malas, reduce 389 to vanishing point. 389 exists in our books. No interpretation can be advanced by the complainant to reduce 389 to a vanishing point. Yes, formally I keep it on a pedestal, but in actual thing it's a hollow shell. There is no role for 389 to play. When will 389 play a role? If these cases far more serious have led to a stay. Otherwise, the only interpretation would be that in no case, even where it is non-societal, non-anti-society, even if it's non-moral turpitude, even if it's non-serious, in no case can you give, because rarest of rare means virtually you can't give. What other circumstances, kindly examine in your Lordship's mind, what circumstance can possibly exist which can then tilt it from the non-giving to a giving case? That's the question your Lordship applies with us as a test. Now, then number 4 is a 332 case. That is hurt to a public servant. Actually, it's a more serious case. On duty, I go and slap somebody. On duty, I go and assault somebody. So it's a fairly serious category. 3 years and etc. That's number 4, Khatik's case. Number 5 is a 7-year maximum case. 420. That is Kushwaha. 420. All conviction, all public servant, all stays granted. 6 is a very interesting irony to it. 6 is Prahlad Lodi. Prahlad Lodi is a case of hurried disqualification. I'll read that in a minute. And in this case of Prahlad Lodi, the conviction is on 31/10/2019, 31 October 2019, and sentence is on 4/11/19. Disqualification order is on 2/11/19. 2/11, that is 2 or 3 days later. And appeal is on 4/11. In my case, my conviction is on 23 March 23. And the disqualification order is 24th of March. There is no way anybody can file with supersonic speed unless we just throw papers at your Lordship without filing a proper appeal in one day. Now, there again, Prahlad Lodi is a stay and of conviction. And last is Olekar's case, Karnataka, again a stay. Now I'm asking myself the question, how is it possible that your Lordship's has so many examples of serious, not a defamation case, which is the lowest rung of this, lowest, not a case which can be said is not serious. This would be a discriminatory application of the law at the behest of the complainant, which your Lordship doesn't countenance. But also keep in mind one thing.
Yes.
Kindly keep in mind one thing. What is it, that can be extra added? Let's look at the balance of convenience just for a minute.
Balance.
Because now I will come back to those 4 points of merits later. But I'm just, since I'm on this part, I'll just finish this part. Let us take all of them together and list them. Your Lordship has to see, of course, prima facie case. There are my first 4 points. I have to come to them. I've already made 1 point, but I will be making more points. Now, assume there is a prima facie case. Then what extra can a man show by way of serious adverse consequences to justify a conviction stay? This is a question I'm asking myself, and I'm attempting to answer it respectfully before your Lordships. One is, the irreversibility of consequences. I'm not saying any one will matter, but I'm taking the totality, but I'm just itemizing. Now, today, forget this case, anybody. I am a public servant in a legislature. I am disqualified. one session of parliament goes, a second session of parliament. So we just stop there, only 2 sessions. Let us say I have missed 60 days. Now that 60 days entails at least 2 or 3 losses. It entails a loss to me of raising my democratic voice in parliament. It entails a loss to my constituency of having their voice raised through their elected representative, chosen representative. And it is a general detriment to the public interest of the country that parliament is without one voice, or legislature is. My question, the first question to myself is, on the 6th month or the 12th month, I reverse my conviction, I am acquitted. Is it ever possible by any contrivance of the law or of the learned judge to restore to me those 3 losses? Obvious answer is no. I mean, even if lordship tries, the lordships can't do it. It's irreversible in the extreme. Now for a minute, assume that my learned friend is not an MP MLA. He has adverse consequences. He also gets a 389 suspension. But in the case of an MP MLA, it is purely on the face of, by the nature of the whole issue, it is irreversible. It is possible that for him, it may be slightly reversible. Look at the nature of this. Then take the other example. Suppose this continues for 3 months or 4 months. There is an established election commission circular that you will not keep a constituency unrepresented for too long. I mean, not that I will have an election tomorrow, but normally within 6 months, you need to have somebody, you can't just keep it vacant. So what they normally do is, if a by-election is happening on the 4th, 5th month, then they'll club it with that. But if a by-election is happening after 9 months, they may have a separate election for this because they don't want to keep it. Now, that's it's a rule of thumb. I mean, it can be 5 months, it can be 6 months, but normally they don't do that. Now, suppose your lordship finds that this person is disqualified on the 5th month. Election commission naturally goes ahead. The constituency is vacant. On the 5.5 months, it has election. And later on, I win my appeal. And meanwhile, Mr. Rawal is elected in that by-election. There is no power on earth. Even a lordship mandamus can't say, Rawal, you vacate your seat and Singhvi will come back again. No power. Nobody can say that. So he's elected. And I have not stood against him. So I have not lost. No election petition can unseat him. No election petition can install me. Well, these are balance of conveniences. For what? For a murder I've done? Well, have I put my hand in the till and have been corrupt? Have I murdered somebody? Have I assaulted somebody? I've done defamation allegedly on a first appeal. Well, defamation has at least 3 more appeals. I have done a criminal defamation at the most at the first appeal level I am standing. I would be disqualified from entire 6 or 8 years, or in effect rendered irreversible by a by-election. And I can't stand, I can't fight the election, and the argument of the complainant is that lordship should read 389 to mean that rarest of the rare case means like a death penalty. Rarest of rare doesn't mean death penalty. It means in a very serious case or a moral turpitude case, your lordship will use the power sparingly. Otherwise, your lordship is being asked to reduce 389 to vanishing point in a category of cases where there is more consequential adversity to a public servant than in a normal case. Well, the normal person has a problem of his wife, unwell, family, livelihood. The additional problem with a public servant is that he loses the seat forever. In that case, you are saying that there will be no remedy in a 389 for a non-serious, non-moral turpitude case. Well, how can that be the law? So on that, well, suppose your lordship were to ignore everything else. Suppose your lordship were to ignore, not that your lordship should ignore, I am coming to the prima facie case. I am just saying, suppose your lordship were to ignore the merits on a pure balance of convenience. Well, balance of convenience is not only civil law, it is also criminal law in 389 in such situations. All the issues, balance of convenience. What is 389? It is ultimately, in simple terms, the lordship sits on the other side also, civil side, 151, balance of, it is basically that, look, ultimately your conviction will be reversed. How can we punish you irreparably? Then we give you a window for a court to consider. Now, with great respect, this alone on irreparable injury, irreversible consequences, with the additional special unique consequence of disqualification, which doesn't apply to a normal human being. It applies only to a legislator. If this is not enough to suspend conviction, then what additional circumstance can anybody have ever? Then actually, by denying in such a case, as the complainant wants your lordships, your lordship is actually rewriting 389 with a proviso. My learned friend, and I'll come in a minute to his locus, in a minute, to be at all here, but that's separate. Your lordship is really being asked by a person with zero locus to say that, look, 389 says you may give a suspension of sentence, provided, however, in the case of a person with special adversity of disqualification, it can never be given. Because if it can't be given disqualification, when can it be given? I can't think of any case where lordships can give it. Now, let us come to those 4 or 5 points of clear absence of a prima facie case. I'm sorry, this chart, I have not finished reading some parts. I'm sorry. Now, lordship will take it. We have given a compilation,
yes,
which has all these cases.
Yes.
Now, either I waste your lordship's time by reading all the cases, it will take time unnecessarily. So, with your kind permission, I will just summarize each case in the chart itself.
Yes.
Remember, on the top, the real point takeaway is, it's a case A, all cases are A of public servant legislators, all of convictions, all of stays. Of conviction, not sentence, we're not considering sentence. All of them. Now take the first one, this Indra Kapoor, which is a PC case. Just keep following it there. As your lordship knows, that suppose the punishment on me is obvious, that is, of course, from my limited experience of criminal law, I have very rarely found conviction than criminal defamation. But where conviction is there, I have never seen a sentence of more than 3 to 6 months. It can happen theoretically. But it should be remembered that in 1 year, 29 days and 11 hours would incur 1 year, 11 months, 29 days and 11 hours would incur no disqualification. It is only 2 years which will incur it. Now, keeping that in mind, come to
section 8.3 of the People's
8.3. So, maximum punishment for an alleged first-time offender in a non-cognizable case, in a bailable case, should effectively make him lose his seat permanently, irreversibly. Queuing of the democratic operating space, because you would have multiple people, and remember the offense has to be kept in mind. Your lordship is not talking of a murder charge, your lordship is not talking of a prevention of corruption. Therefore, it's a very serious, extreme situation which cries out for redressal. 389 was only created for this. There's no other place it can operate. Now, I'll just see these cases. Kapoor is the PC case I mentioned, and this saves time a lot because this is only the relevant para which are given there. No, I'm reading the same thing in the chart.
Chart, I have seen that. I have marked it.
I'm grateful. Why is the part?
Also,
Page 627 the compilation.
Oh, that you lordship can note on the side. I mean, otherwise you lordship to see the whole thing. I don't need to read the whole judgment. Lordship will see the whole judgment, not be. It's all there. Well, though appeal is to be decided by this court on merit, but having taken note of the aforesaid aspects, this court is of the view that the case at hand comes under the category of exceptional case. What comes at hand? PC case comes under exceptional case. In case conviction is not stayed, petitioner's political career would be ruined. I would request my lords to mark whatever lordship thinks is appropriate, but these are vital words as far as I am concerned. Well, incidentally, if time goes and there is no stay of conviction, the disqualification is 8 years. Because 2 years is anyway, and then 6 years. For the reasons stated, this is the heart of democracy also, even though you are a convict, your chance of again, this court finds that on account of conviction, petitioner has been rendered disqualified to be a MLA and in case conviction is not stayed, she would not be able to contest the elections which are otherwise bound to be held on 12th of November. Here, well, is the maximum, about 2 months have gone, and the election commission would not normally wait for more than a couple of months more. Normally, but it's 2 to 3 months more. Since conclusion of appeal may take some time, and in the event of appeal being allowed and the applicant being acquitted, she cannot be compensated for the loss which she may suffer on account of a losing chance to contest elections to Himachal Pradesh Vidhan as a member of the assembly. No doubt, power under 389 is to be exercised sparingly. This is exactly I am commending to my laws for kind consideration. No doubt, power is to be exercised sparingly with circumspection so as to stay the conviction. Yet it is equally true that principle of law is to be applied as per peculiar facts and circumstances of each case. There cannot be a straitjacket formula, rather, each case to be examined in its own peculiar facts. In case conviction is not stayed, she will suffer the consequences which cannot be compensated subsequently in any terms irreversible, accordingly in view of the detail held, etc. etc. Now, two things just pause here. This is particularly applying to everybody who is sitting MLA or MP, not to a person otherwise who may also have serious consequences. As I said, he is a non-public servant category, I am a public servant category. It is not that he doesn't have serious consequences. He is equally entitled to 389. But there is a supra-added unique facet to me, which is in any case for us very serious, per se by definition, because he doesn't lose irreversibly a seat. Then number 2, Mohammed. So in keeping his view, this again is a PC case for us. Sitting MLA of Odisha, the loss befalls on him due to the conviction will be irreparable unless the same is stayed. This will also lead to an untimely by-election. So all the tests I have said, are found here or there, everywhere. The test is either of these 2 or 3. On all tests I qualify, is my humble submission to your lordships, for lordship's kind consideration. On each test I qualify. To burden the public exchequer, further considering the limited period of his sentence for 3 years. Limited period for 3 years? I am I know. I am only 2 years. This is called limited period. I don't know what my period is called, which are neither punishable with death nor imprisonment. It is felt apposite to grant stay of the conviction pending appeal, since the impact of the loss due to disqualification will not only be enormous for the applicant, but also for the public exchequer. The appellant has the statutory right to prefer appeal under 374 against his. The first appeal I am on.
Yes.
It's not that I've lost 3 appeals, but I am coming on a SLP on the Supreme Court. It's my first appeal. But also note, these cases are saying that per se the potentiality and the possibility of permanent disqualification is by itself sufficient to stay. Each of these cases is saying per se, by itself, what lawyers call ipso facto and ipso jure. That is a good enough test. Then third one, I'm sorry, the last line, no reason is found to make a narrow interpretation to debar the petitioner from disqualification. No reason to make a narrow interpretation. Then there can be another third case. There can be disemphasized the burden put on the constituency and on the public exchequer. This third case, which is now in the Supreme Court, and where no stay has been granted till now. Although the complainant has argued many times for a stay, and the state has also argued for a stay of a stay. There can be no quarrel, and it was not disputed that if a sitting member of parliament is convicted and in the appeal a stay or suspension of conviction is granted by the appellate court, the disqualification will cease to operate from the date of suspension. On consideration of the various legal and other circumstances, the special features arising, especially those related to the second petitioner, this court is of the view that the case of the second petitioner falls in the category of rare and exceptional circumstances. The ramifications of not suspending the conviction are enormous. What more can anybody say? Hence, this court is of the view that the conviction and sentence imprisonment imposed upon the second accused on the files of the sessions court, etc., should be suspended until. And at the end of the day, a dog has his day in court, is the old saying. Why will I not get my first appeal right, to exhaust? And if I have a good chance in the first, that's why Lordship looks at prima facie case. Suppose I'm in first appeal on a useless case, unstatable case. Suppose the Lordship has a case where somebody says that in a particular room, he saw Mr. Singhvi pull out a gun and in front of everybody shoot so-and-so. The prima facie case becomes very weak. And he had the old enmity. But where there is a clear prima facie case and I have a right in my first appeal Effectively, it means denying to me all the possible benefits of a first appeal. I win my first appeal after some time. What is the use of victory months? Most of my victory is a hollow victory. Most of my victory, at least a chunk of it, is a hollow victory. In such circumstances, I am now the fourth case for this, fourth case. Depriving her from contesting election would be injustice. It would amount to frustrate the provisions of law, which has been made by the legislature to pass appropriate order to meet a situation exists in the present case. What is the situation, Malas? Only this.
Only this.
I am an MLA, MP, I lose my disqualification and my seat. Then fourth, Kushwaha. Here, Malas, 420, I'm sorry, this last one, Malas, this Khatik was 332, assault, etc. on a public servant. This fourth fellow, Malas, is 427 years maximum. Here in this case, contended by counsel, if the stay is not granted, appellant 2 would be disqualified to hold the post of
Then
member.
it is relying upon the earlier judgments only.
I'm grateful.
Yes.
But Malas, all of them are emphasizing that the main exceptional circumstance, the main important circumstance on which we are giving you stay of conviction is your disqualification. Per se, it's a test.
Yes.
Considering the orders passed in Lodi and Khatik,
Yes.
not proper for this court to give any finding on merits of the case, prima facie regarding. So, Lordship is right. Your Lordship is not going to give a finding, but prima facie is still equally. Your Lordship find there is no prima facie case. Your Lordship is a useless case on the merits. So, your Lordship does that. When your Lordship passes on the civil side, a 200-page judgment, sometimes on order 39-1, although I believe it should be shorter judgments nowadays on 39-1. Your Lordship does have to pass a prima facie view. At the end, your Lordship says this prima facie view to grant an injunction or not to grant an injunction shall not affect the trial judge. Same thing happens in criminal law. It doesn't mean that your Lordship says, okay, it's a prima facie case, but I am prejudicing the appeal court. Not at all.
Yes.
At this stage on merits, but prima facie, considering the evidence available on record and findings given, appellant 2 is entitled to get relief, which is claimed in his application, seeking stay on conviction. Because the same is not granted, he would suffer irreparable loss as he, why? What is this? Only this. As he is an elected member of the Legislative Assembly, would be deprived to continue to hold the said post, can also be deprived to contest the election of Assembly. As such, application for staying the conviction in respect of appellant 1 is not being considered and allowed, because as per facts, reasons assigned so and so, prejudice would cause only to appellant 2. Therefore, conviction only of appellant 2 as passed by the special judge shall remain stayed till the next day. They made a difference between appellant 1 and appellant 2. This fellow will suffer disqualification, so I am staying it. This fellow may not have the same malas benefit. Prahlad Lodi malas, just forget everything and just come to 26 in the middle. And 27.
27 also.
And 27. I am grateful. On the basis of foregoing discussion, etc., etc., this court found a strong case. Learned senior counsel appellant submits that conviction and sentence was recorded against the appellant. This is what I have given us the dates: 31st October and 2nd November. Well, this is another thing which is happening. Just kindly see. It's all right. I'm not blaming Wallace that there is to be an old saying that because you have the power to do something doesn't mean that there are no fetters inbuilt without saying so in the powers, the manner you exercise. Now, Wallace, there is no limitation that today, Wallace, I am convicted and tomorrow the master of my house issues by tomorrow, today evening itself, he says you're disqualified. There is nothing in the act. Does that mean that the exercise of power is fair, valid, reasonable? Is it, Wallace, just step back for 30 seconds. Is a conviction of a criminal court, and I was very amused to see on television, etc., everywhere, a lot of unasked, gratuitous advice. Yes. Somebody would say, look, if I was there, I would file an appeal in 8 hours. Somebody said, if I was there, I'd file an appeal in 24 hours. Well, there must be supersonic lawyers who can do it. But the point is, are we here to do supersonic filings? That I just jump into a lordship's court and say, look, I have got half the thing translated, I have not got the thing, but look, this disqualification is happening tomorrow. Your lordship may take my half-baked appeal and please deal with it immediately. Now, this is that kind of case. This fellow here, was 30th, 1st of October and 2nd November. That is still 48 hours. Mine is 24 hours. Mine is actually less than 24 hours. Directly same case, is mine. This was a case, of injury to public servant. This Lodi's case, injuries. And see what they say in the later part of 26 fellows. In very hurried manner, dismissing the membership and declaring the seat vacant. In these circumstances, stay of conviction is very necessary. Peruse the order. Court find there is urgency for staying the conviction. Then last one fellows is sitting MLA Kolekar Karnataka case. This is a, I'm sorry, yes, I've just checked up. It's the PC Act. Every case I have given falls squarely and rightly and harmoniously in a moral turpitude category or a serious offense category. I had not given this offense here. It's PC Act. And will going to contest the upcoming election, way of operation of law already disqualified. If the conviction is not stayed, he cannot contest the election. Therefore, in view of the judgment, etc., low priori, it should be stayed. The last sentence is that now this is another. This I am coming to separately. So this is one part. Now just digress for 2 minutes before I come back to the merits. This touches on the larger issue also and partly on the complainant also. Please note that you have imposed the maximum sentence on the first time on an alleged first time offender. In a bailable non-cognizable case. It can't be a lower category, maybe some traffic offense may be lower, otherwise. And in a case where the Act 499/500, the Act itself says that everybody at this table cannot file a complaint. Only if he is hit, only he can file. If I am hit, I can file. That is not the norm, it's an exception to criminal law. I am told there are only 22 cases in the IPC. One of my learned friends here checked up. 22 categories only where non-cognizable and bailable are there. Involving simple imprisonment. Under 499, the only consequence can be simple imprisonment. There are only 22 such cases. 22. Now, just note this. In this situation, let me take it. This is a well-known thing, sir. In this situation, I am convicted for the max. As I said, 1 day less would not have incurred the disqualification. 1 year, 11 months, 29 days. I am convicted of the maximum. But the magistrate, forget the sessions court, that's been the stay of sentence on the first day. And the sessions court subsequently has paid the order absolute, if I may use the civil law word, till the disposal of the appeal. Namely, there is, in that sense, to be colloquial, there is bail till the end of the appeal. So I am convicted, but I have no sentence. At least till I lose my appeal and then we see what happens. Now, your lordship knows that this is a non-societal offense, clearly, state is playing no role. Cannot play a role as a matter of fact. In this case, today's case, the state did not even appear in the magistrate's court. Actually, factually did not appear. It is a non-societal case. They do not have locus. Apparently, I don't know the reason. Maybe the cameras did it. In the sessions court, somebody appeared for the state, but did not argue at all. I don't know what will happen to in the high court level. Cameras will become more important, but I don't know. This is a threefold stage at the moment. Now, the learned complainant, forget this case. Your lordship dealing with so many more criminal cases. We do only some occasionally. In criminal law, he is a complainant. What does he do in a novel? He is hit and aggrieved and hurt. And the philosophical underpinning of this is that society will become chaotic unless these people get redress. Society will become dispute resolution on the streets. So first thing is he has to be aggrieved. He has to be hit, hurt. He then has a right to prosecute that hurt. Prosecute not in the technical sense, but complain, go to a court. So first right is complain. Third is that he can supervise that, look, the PP is not going astray or something is not happening. Your lordship is given limited rights here and there in statutes. Your lordship sometimes says he can stand there and watch, but he can't participate. All those things your lordship says. Then he can say, no, look, please, according to me, you should convict. He can tell the judge in some form or the other. At the most, after conviction, he can say, look, you must punish him. Now, whereas all that has happened on the date of the magistrate's order in my case, the 23rd of March. After I've been convicted and the conviction has happened and sentence of the maximum amount has happened, the complainant has no role there. Kindly take it further. Wallace. Complainant then, very interestingly, this complainant in this case, in front of his nose, I am given a stay of sentence and that stay of sentence is made absolute now. He has not challenged that. At all, if at all he is aggrieved or concerned, it would be that, look, Mr. Singhvi is going scot-free. He has not challenged that in any form. Then, Manoj, where does he get locus to challenge a stay of my conviction, which is relevant only for disqualification? Whereas today, when he comes and objects towards stay of disqualification,
We have not issued any notice.
No, I'm very sorry to
I'm
interrupt.
talking about the lower court.
You know,
We have not.
advance papers are and copies are served upon my advocate.
I'm
That's
saying
why we are
something- I'm
here.
talking of law, Manoj. I'm saying
No,
something
no.
else.
So we are here. You need not presume unnecessarily.
No. I'll be very
That
happy.
we are
when
called upon.
We'll find out whether I've made a self-fulfilling prophecy or not in a moment. We'll find out shortly. But
Yes.
that apart, I'm not at the moment talking of the Sessions
Your
Court.
advocate is served.
Sessions Court. Of course, we have served copies advisedly.
That's
Because
fine.
we are in a hurry, Manoj, and we are wanting a decision this way or that way. So we have served copies. We are wanting a decision this way or that way. So that people don't come and say that we were kept in the dark, we don't want it. I am saying something quite different. I am saying that till the Sessions Court, let us assume Mr. Nanavati, my good friend, is not here. Till the Sessions Court, the complainant has been playing a role. He came, argued. My question to myself is very different in law. I am asking a legal question. I am not asking about Mr. Nanavati or this complainant. I am saying what can be the possible interest of a supposed Mr. Nanavati client about disqualification. His interest is that this crime is prosecuted, it is brought to fruition, somebody is convicted or acquitted, somebody is sentenced. It is not that after that, my lords, don't give Mr. Singhvi stay of conviction so that he is disqualified. That can't be the role of a complainant, Malas. It is between the court and me. I can understand that. In a rare state where there is a murder, it would be between the state and me. But Malas, how does a complainant get any locus to say, Mr. Singhvi is convicted, I am happy. Mr. Singhvi is sentenced, I am happy. Mr. Singhvi's sentence is stayed, I have not objected, at least for the time being. But I will object. Because Mr. Singhvi must not only be sentenced, but he must be disqualified also. What? It can't be locus, Wallace, at all. There is no such thing. As a matter of fact, Wallace, your lordship has enacted a section 378(4), which is frequently forgotten, which says that at the appellate level, he comes in only on the basis of 378, not generally, which is, Wallace, against acquittal. And then, even there, against acquittal, he has to take a special leave. 378(4). So I am putting things in perspective, Wallace. I am saying it is not, Wallace, some kind of bloodletting between some complainant and some accused.
Yes.
This is a very different kind of jurisdiction.
Yes.
I now come to, Wallace, the other. So I've done, Wallace, out of my 6 points, I've done, Wallace, 3. No, now, Wallace, I was on the point of the prima facie case, 3 broad things. And under one of them, Wallace, there are sub-points about vitiating trial. But let me give you the first of those. The first is, Wallace, that your lordships has, now I'm showing why, Wallace, according to me, and I may be overstating it, of course, but I'm just making a respectful submission. According to me, Wallace, this is a case which must fail against me, or rather put it other way, the appeal must succeed. Only to show prima facie, not to get a lordship's finding. I've made that clear, Wallace. For the first simple reason that the jurisdictional basis of kickstarting this complaint is that any one of the persons with that surname constituting, and I'm surprised to learn that. I don't think it's correct, but that's the basis of the complaint. I'm not saying anything. Any one person or member of a class of 13 crore people can maintain a complaint against me. That is the basis of the complaint. The persons who are named in that are not complainants. Number one. The persons who are complainants base their complaint only, I repeat the word only, that they are one member, or in another city, 2 members from a class which they define, not me, as a class of 13 crore people. Now, Milits, the condition precedent of defamation law, and this is peculiar law, it is not normal criminal law. Under 499 itself, in the section itself, forget the case law, which I'll be citing in a minute, is that either you must be the aggrieved party, admittedly is not the case here, admittedly. Second, the complainant concedes that Mr. Singhvi never named Purnesh Bhai Modi. He concedes in writing. Third, the only basis of the complaint is that anybody out of a class, the law, I'm sorry, is that such a class does not constitute an identifiable class. It's not a legally known collectivity. It is not a legally known association of persons. It's not a legally known family. Well, I will go further. I'm not calling of this case. This is case law, not me, directly. This is because the idea is to prevent large sections of people filing defamations. Defamation is the closest to a bilateral offense. Whereas civil suits are bilateral. They are between A and B. They are not in rem. Crime is normally in rem. Normally. But there are special crimes which are in personam. Defamation is one such crime. It is intended to be in personam. I'm using a civil law word, but you should understand what I'm saying. The in personam aspect of defamation creates the bar in 499. It creates the second bar saying only the agreed person can sue. Now you can't circumvent it by creating your own class of a non-identifiable, non-definable, non-decipherable, non-boundaried class called 13 crore people with the same surname. That's fellows, and that's a serious lacuna of law. If you do it, if you allow somebody to circumvent the law like this, then fellows, the law is made a fool of, because the law says you can't do it in a direct way, but you're doing it indirectly. Now on that, fellows, just note, first see 499 for a second. Fellows. Therefore, fellows, at the door, when my learned friend's client entered the door, it was a non-maintainable criminal complaint. There was no criminal complaint in the eye of law, which could have been filed. If this is true, Malus, then Malus, anybody of, Malus, even if I say that a family by the name XYZ, or I will go further against myself, families comprising the XYZ community living in villages in Uttarakhand which have that community. Your lordship may have an identifiable card because some villages are community based. But you cannot say that all 13 crore people of a surname, none of whom I have named, the person I have named, 3 people, have not sued me. But none of those I have named, anybody can sue. That is not the law, Malus. 499. Kindly see the relevant portion of 499. Lordship, see, Malus, unlike other sections, by the way, this section has lots of explanations because the idea is to make it bilateral. Now, first see whoever by words either spoken or intended, that I'll skip, Malus. Except one thing I'll not skip. To defame that person, the last line. It's a that person offense. Last line of the first thing. Now come to explanation 1, which is, well, it's deceased. Leave it.
Yes.
Then explanation 2. It may amount to defamation to make an imputation. Now this is the only collectivity you recognize. It's a statutory limitation on the collectivity you recognize. Which A company, B, an association. 3, a collection of persons as such. Your lordship has defined in your case law broadly what a collection of persons mean. But I can assure your lordships, obviously his case is not of a company. There is no company with this. His case is not of an AOP. Association of persons is an AOP. Now, the case law makes it clear that collection of persons as such doesn't mean what my learned friend might like it to mean. It must mean a identifiable boundaried class of persons who is not amorphous and vague and woolly at the edges. That's the meaning in case law directly. Otherwise, your lordship is being asked to make a mockery of defamation law by the complainant, because defamation law then means a walk in, walk out. Anybody can come, and tomorrow, frankly, if this is the law, then there is no limit. What is the point of 499 limitation? In fact, according to me, it will be a more wider door than murder. My understanding of murder is that anybody can make any complaint of murder. This will be wider than that also. Yes. And 199, just see here, along with 499, which gives the lordship the procedure for just a minute. Because this is against unique, because there are very few offences for it. Your lordship makes a new provision, a separate provision for defamation alone. Prosecution for defamation, no court bar, prohibitory bar, no court shall take cognizance of offence punishable under 21 of the IPC except upon a complaint made by some person aggrieved by the offence. Purely the closest to a personam bilateral equation or matrix, not a generality. Now, keeping this in mind, just see 4 or 5 very starking points, very, very astonishing points. It is there. At the moment, it's okay. But keep it around. I need it. Now, let's just see. Let us see some parts of these statements. You'll also be shocked what is happening. I made the point about 499 and 199.
Yes.
That will also be seen. Now, let us just see page 25 of, I believe it is CC 1?
I'm just giving.
CC, yeah.
I'm just.
We made a
passing
convenience, otherwise. I hope this convenience compilation itself is not an inconvenience compilation. Sometimes become very fat.
In SR matter, you have perhaps done that.
Oh, I see. My lord was sitting in the division bench. Sir.
Yes.
I hope the lordship doesn't hold that against me, because I inherited that CC. I came into the case only in the final hearing. That CC was filed much before that. I believe the lordship was sitting with Justice Gokani. Yes. But I inherited that. I did not create it. I can show you lordship. 25 is here.
Yes.
Page 25. Just this is the evidence of the complainant. I'll be very pointed, but I will not read much of it. Just the relevant part. My residence falls in the limits. That's got that sentence at page 25.
Yes.
I read the aforesaid WhatsApp message, etc.
Yes.
I'll just come 4th line. I filed a complaint because I belong to the Modi community. That is, I come from the Modh Vanik Samaj.
Yes.
Modi community is known as Modh Vanik Samaj in Gujarat. Subsects of Modi community are Rathod, Teli, Modi, Khanchi, Chaudhary, Das, Chettiar, Shahu are found in different states of Gujarat. The implication of this judgment is that any of them remotely calling as a subsect also, any individual out of them, man or woman, can maintain a complaint. Insult and humiliation are caused to 13 crore people of Modi community. Probably means all these subcastes, and I don't know, I'm not at all agreeing to the count, but I'm assuming what is said there. This is the count. Due to utterances of so-and-so, the individual reputation of people belonging to Modi community and people having Modi surname in the entire country is damaged. And Sri Gandhi was aware of this fact that he has made such kind of statement to gain political mileage. Now, this is on the face of it. I read the case law, which I'm coming to in 2 minutes. Your community in the generality of a undefined amorphous allegation is per se not defamable. I am giving a lordship a jurisdictional ground, no evidence, nothing, per se. If I say tomorrow, Malas, that all XYZ community, one community, are bad, you must, Malas, you cannot have any member and can be a very large community, Malas, filing a complaint, because that's the law. The law is to be still read by me. No, it's going to sequence one second. The other page to be shown is separately. Now, Malas, the other thing is, just turn to the judgment of Subramaniam Swami, Malas.
Yes.
Page 116 in the judgment. Page 116.
116, I am told.
116.
But there is an irony here, Malas. Very funny irony, Malas. Malas, Dr. Subramaniam Swami filed this petition, Malas, saying that the whole criminal defamation should be abolished because it's unconstitutional by 19(1)(a) and this and that, Malas 21. But the main counsel defending it and appearing against him was me. And I was able to persuade Justice Deepak Mishra's bench that constitutionally it is not invalid. Now, Malas,
Sometimes it's happen.
yes. Now, Malas,
Circle is go around.
no, Malas, there is no estoppel against lawyers. Malas.
Yes.
Estoppel applies only against judges. Estoppel applies only against judges, Malas, not against lawyers. Now, Malas, 177, your
Yes.
lordship will come to. Actually, start from 176, but forget 176. Kindly come to 177, which is at your lordship page 116. I think.
Page 116. Page 116. Para 176.
Para is 176. In Narsimhan, the court dealt, does my lord have it?
Yes.
177.
Yes.
In Narsimhan, the court dealt with the applicability of the said explanation as regards associate lordship, now dealing directly with 499 word and 199 word and concept of association, directly Supreme Court. In Narsimhan, the court dealt with the applicability of the explanation as regards association or collection of persons and ruled that a collection of persons must be an identifiable body so that it is possible to say with definiteness that a group of particular persons as distinguished from the rest of the community was defamed. My learned friend is saying the opposite. He says not only is the Modh Banik Samaj, but there are 10 others, Rathors, Telis, all are included. The reverse direction. Therefore, in a case where explanation 2 is resorted to, the identity of the company or the association or collection of persons must be established so as to be relatable to the defamatory words or imputations. Where a writing weighs against mankind in general or against a particular order of men of down, our community, it is no libel. In fact, I've got 2 cases, Balas, where lawyers as a collectivity were alleged to be defamed. Gujarat High Court judgment, I've got those judgments. Although, Balas, I remember, Balas, that just to digress 30 seconds, Mr. Khushwant Singh, who was known to me, although I'm much younger, Balas, wrote decades ago a book where he put a para which was vitriolically, viciously against the profession of advocacy. I apologize, but he said it is the second oldest profession in the world. And he gave a whole paragraph after that.
Okay.
It's typical Khushwant Singh style, your lordship knows this. He was hauled up and he had to apologize, otherwise he would have been possibly convicted. That's an old judgment from long ago. But in private, he used to say that I stand by that. Anyway. Where right, just look at these words, Willis. This is more categorical. The allegation here is the entire 13 crore persons, much more vague and unidentifiable. Here, where a writing weighs related against mankind in general or against a particular order of men, that is men of gown, it is no libel. It must descend to particulars or individuals to make it a libel. Thus, the accentuation is on particulars. In Khushbu, it has been ruled that Tamil Nadu,
Yes.
is wide, yet in order to demonstrate the offense of defamation, such a collection of persons must be an identifiable body. So it is possible to say with precision that a group of particular persons, so as distinguished from the rest of the community, stood defamed. In case the identity of the collection person is not established so as to be relatable to the defamatory words or imputations, the complaint is not maintainable. It has been further opined that in case a class is mentioned, if such a class is indefinite, the complaint cannot be entertained, and furthermore, if it is not possible to ascertain the composition of such a class, the criminal prosecution there cannot be, of course, your Lordship has to say it case by case, but there cannot be a more ex facie obvious case where this applies according to me. One more paragraph is 178. The aforesaid enunciation of law clearly lays stress on determinate and definite body. It also lays accent on identifiable body and identity of the collection of persons. It also significantly states about the test of precision so that the collection of persons have a distinction. Thus, it is fallacious to contend that it is totally vague and can, by its inclusiveness, cover an indefinite multitude. Every word, every adjective applies to a case. The court has to understand the concept and appositely apply the same. There is no ambiguity, be it noted that Anita Hala has ruled that for his company's own reputation or something else. Or what? 230? 231 well is lower down. 231 of this page. This page. Which case? Anita Hada. Anita Hada.
Yes.
No, I'm well, just very well, they were diagram. Well, the lawyer's case is page 231. 231. Yes, fine. Put yours here. $231 my lord is got
Yes.
at Wallace A. Wallace, your lordship may just tick 57 and 58 before that at page 226, but I will not read it.
Page
226, para 27 and 20, sorry, para 57 and 58 at page 226.
26.
Yes.
Yes.
But now come to the relevant part I want to read. Para 60,
Paragraph 71.
67 for a minute, Wallace.
Yes, thank you.
71 also. 67. The complainant himself nowhere refers to a determinate section or a group of lawyers in respect to whom the insinuating writing is published. He positively refers to the entire world of lawyers, Vakil Alam. That is the footing on which the Bar Council proceeds. That is how the instruction is given to the Council of the Bar Council. As far as the record of the petition is concerned, the fact remains the Bar Council has proceeded on the footing that the editorial pertain to all the lawyers and the subject matter of the petition concerning lawyers class as a whole. Thus, the submission is contrary, etc., not even supported by material record. And then, Mullah's 68 also, Lordship sees the editorial does not refer to any specific individual whomsoever. It does not refer to any institution of lawyers. That is to say, Taluka Bar. So, Mullahs, they are narrowed down even to a Taluka or a district court. But even that is not there. And then your Lordship rightly said 71. I'll leave. My Lord knows this case. 71. 70 is the thieves thing, but Mr. Khushwant Singh's paragraph is much worse. I've read it. I've read it. This is quite mild compared to that. This is quite mild.
You are emphasizing Khushwant.
But only thing is, we are saying this, fellows, because one of the allegations in my case, of course, fellows, the separate point is that none of these have been proved that I said this. That is an important point. There is no direct evidence, no documentary evidence, no visual evidence, nothing. But for a minute, taking the allegation on a dimmerer, I'm only on a dimmerer. Fellows, the word thieves is used against me also. And the word thieves is in 70. That's all I'm saying. That is the only purpose of it. Otherwise, and then Malus 71 is that company and collection. So let me leave that now. The Lordship is aware of this case anyway. Let me come Malus to one second. Let me Whereas my learned friends are insisting Lordship to take 74 and 75 also, because they are talking of individual and collectivities.
Yes.
That's all whereas there is relevant for it. The same concept which I said orally, but they are dealing with it directly. For example, just see 74. Complainant is himself not an agreed person, since the writing does not relate to him individually.
In fact, it is related to paragraph 81. Please can you read?
I beg one.
Paragraph 81.
Yes, straight away. Goodbye, Lord. Give me 1 minute on 74 minutes. Just 1 minute. He is not an agreed person, since the writing does not relate to him individually. As provided in the 199, unless it is prima facie shown that the complaint is filed by an agreed person, the court is precluded, etc. And 75 malus is at this stage may consider as why imputation made by a person in respect of an indeterminate section of the society. There are two things. Now 81 malus, as my Lord says. It must be remembered that the legal profession has a vital role to play. Central function of legal profession to promote administration of justice. Practice of law is a public utility of great importance. Lawyer, by the very nature of his occupation, fills in a public character. Those who fill in public positions must be little thick-skinned and learn to ignore certain criticisms. In this connection, reference will be made to Kartar Singh. And they say one of the most important qualities of those in public life is to be thick-skinned.
That is why.
No, it's not easy. Most people are not, but that's a very useful quality. Actually, it's very useful. To be oversensitive, Malas, is self-destructive. Then, Malas, those who fear public will not be thin-skinned in reference to comments. It would often happen that observations be made upon public men, which they know from the bottom of their hearts. Malas, the learned complainant here was a very high post-holding minister, Malas. Perhaps this advice should go to him also, Malas. But anyway, that I leave that way. I'm not applying it to this case. Now, Malas, I want to just finish this point by 2 or 3 more things, Malas.
Yes.
Page 25, my Lord, is noted.
Yes.
Now see 2 more pages, 64 of the CC and 70 of the CC. Convenience compilation. CC means convenience compilation.
Page number
64.
64. Yes.
Well, the Lordship knows that case. Your Lordship's High Court, in the other case which I am not reading, Madhwani's case, which we have got also on the compilation. Madhwani's 2003 SCC follows this same judgment. Both are from Gujarat. So Lordship will just make a note of it, but I am not reading it to save time. Now come to 64. This 64 is evidence of another person called Rathod, Exhibit 60. This page 64, right?
Yes.
It is true that my surname is not Modi. It is true that I have not produced any evidence in connection with what is my caste in this matter. It is true that the accused has not used the word Teli Ghachi or Mod Ghachi in his entire speech. It is true that Soma Bhai, brother of Shri Narendra Modi, is the president of the Samast Gujarati Mod community. In that capacity, he is giving evidence for this. I have close relation with him, and I also have close relation with Shri Narendra Modi and his family. The Samast Gujarati Mod Samaj, about which I told you, is a trust. That means we have created a trust in the name of Samast Gujarati Mod. It is true, of course, none of these names are complainants. Complainant is some other person. It is true that we have not produced the scheme of the said trust in this matter. It is true that any person can create the trust in any name, and therefore community and trust are 2 different things. Then I will skip some lines with the Lordship's permission and come to 6 lines below. I will of course read anything else required, but I don't think it's relevant. It is true that the name of the Akhil Bharatiya Telik Sahu Mahasabha does not include names like Mod, Vanik, Kanchi or Modi. It is true that I have relation with the complainant, Purnesh Bhai, and as we have to carry out all this work together, we have a close relationship. This is Malas one part of the, I'm only on the first point, identifiable class, maintainability of the complaint, validity of the complaint as a maintainable issue. Then Malas turn to 70. 4th line. It is true that most people belong to many other communities. Now, how can it be identifiable class? The person himself is saying it's a conglomeration, as is true of India, because India is like that. It's a conglomeration of diverse castes, subcastes, subsects, subgroups. You cannot possibly manage a defamation bilateral situation if you give a locus to anybody. It is true that most people belong to many other communities. It is true that I do not have any such evidence. I do not have any such evidence proving that since our Kuladevi is Modheshwari Mata, we are known as Modvanik. It is true that nothing has been written. I will skip that map, or 10 lines I will skip. Then same page below. It is true that even if one has Modi surname, he could be doing any type of business. It is true that Modi's surname falls under many other castes also. Well, there cannot be a more amorphous, open-ended caste. Well, in Rajasthan, we have a lot of Singhis in one part of the western Rajasthan. Outside Rajasthan, we don't. But that even is considered very wide in that part of Rajasthan. But still, it is a more definable class with a common Kuldevta, etc. But that is, in comparison to this category, we have very, very small class. Because see what is happening here, Manas. It is true that even if one has Modi's surname, it will be doing any type of business. It is true that Modi's surname follows in many castes also. Nirav Modi does not belong to our caste. Mehul Chokshi does not belong to our caste. Lalit Modi does not belong to our caste. Lalit Modi is also incidentally threatened to sue Manas. It is true that Vijay Mallya also does not belong to my caste. It is true that these four persons, Vijay Mallya, Mehul Chokshi, Lalit Modi and Nirav Modi, with whom Rahul Gandhi had made comparison of Shri Narendra Modi, out of them none is belong to the caste. Out of them none is belong to the caste of ourselves or that of Shri Narendra Modi. None of whom are complainants. None of whom are complainants. Then 71 in the end.
Yes.
And then I have read that, that part I have read, 71 on the top. And then just see two more cases. Now one more thing, CC page 33, 34 and 35. This is very important. The same CC, have I read this 33?
Yes, sir. So this is,
No, I'm not reading.
no, you haven't.
This person, is a deposition of the complainant. That other fellow was Rathod. This is the complainant. Bottom last line of 33. It is true, last line of 33. It is true that my surname Mod Ghanchi is not written in my complaint. So he said, I am Mod Ghanchi, I did write it in the complaint. It is true that my community is written as Mod Vanik in para 6 and 7 of my complaint. Mod Ghanchi is not written. It is true that any documentary evidence is not produced to support the fact that Mod Ghanchi and Mod Vanik are the same. I changed my surname from Bhutwala to Mod in the year 88. So he accepts that I have in a sense suppressed and I have no evidence to show otherwise. Now come to 35. This is the complainant himself. Fourth line of 35. It is true that Rathod, Gupta, as Gupta is also here, Teli, Modi, Ghanchi, Chaudhary, Das, Chettiar, Shahu. Castes are not subcastes or units of Modi community. Witness willingly says that they are complementary to each other. It is true that he has not produced any documentary evidence to show that they are complementary to each other. It is true that Samast Gujarat Mod Samaj Trust came into existence from 2015 only. Before that, there was no such kind of trust. It is true that there is no government record belonging to me showing my community as Mod Modi. It is true that Modi's surname is found in various castes and communities. It is true that Modi's surname is found in various castes and communities. It is true that Modi's surname does not mean that it is a certain community only. It is true that except Exhibit 30, I do not have any other documentary evidence to show that a community is existing in the name of Modi. Now, 30 is what, Manas? 30 is a letterhead, blank, of the Mod Samast Gujarat Mod community.
They are just saying that this is.
There is one typographic error in translation, it appears.
Oh, I see. Very well.
એ વાત ખરી છે કે મોઢ ગાંચી તથા મોઢ વણિક સમાજ એક જ રીતે હું દર્શાવવા પાછો 1988 માં ને ભૂતવાલા સરને બદલીને મોદી કરેલી નોટ મોઢ.
Okay.
Very well. No problem.
Thank you,
No
sir.
problem. We'll make it corrected.
I'll-
We have put more.
I'm sorry.
Right. No problem. No problem. So well, just note this. It is true that except exhibit 30, that is well, page 35. A very important sentence. I do not have any other documentary evidence to show that a community in the name of Modi exists. But what is the 30? Exhibit 30 is a letterhead of a trust he created in 2015. A blank letterhead. Obviously, letterhead. There is no meaning otherwise. Well, as a man creates a trust calling Modi Samast Gujarat Samaj and says, I have no evidence other than this to show that there is a Modi community, and maintains a complaint on that on an identifiable class of persons, despite 499 and 199. That's the whole case of this. Nothing else on this. Two more quick judgments and I'm done on this point. Was Narsiman is, which page is it? No, just give me this Narsiman.
Nursing.
Yes.
One.
Well, 138 of the first paper, first judgment's compilation. And relevant is Balus, para 14. Pages 143, Malus of para 14. On these contention, the principal question for determination is whether respondent could be said to be an aggrieved person entitled to maintain the complaint within the meaning of 198. That section lays down that no magistrate shall take cognizance, so far as this limitation is put there, except upon a complaint made by some persons aggrieved. 199 says an exception to the rule that a complaint can be filed by anybody, whether he is an aggrieved person or not, and modifies that rule by permitting only an aggrieved person to move a magistrate in case of defamation. The section is mandatory, so that if a magistrate were to take cognizance of the offence of defamation or a complaint filed by one who is not an aggrieved person, the trial and conviction of an accused in such a case by the magistrate would be void and illegal. You can't, Malas, say that first thing says only aggrieved, second thing says it's the least offence, third thing says I'm expanding it for a company, for an association and collection. Slight tweak. But in that, Malas, slight hole, you bring in an elephant. As they say in Hindi, पूंछ के साथ साथ हाथी भी अंदर आ जाता है. Hathi can't be allowed, but otherwise the idea is to give a very small hole for some little collection of people to go through. That is the identifiable class of people. That small hole to allow a collection of class of people, known, identifiable, defined, doesn't mean an elephant of an amorphous kind who is not at all known is why. That can't happen. That's the point. Then there is a Kerala single judge which I will not cite. Just note the page. It's at page 151, the relevant part, at paras 26 and 27, which says the same thing, since it's only of persuasive value, but it's an important judgment. Kerala Malas. The relevant portion is 151, and the relevant paras are 26, 27, and 28. And Malas, I make bold to say one thing. Malas.
Yes.
All these cases which I am citing are cases of much more identified, much more narrower, much smaller classes which were held to be indeterminate. Every case. If at all, Malus, they were not as amorphous and large as the Samaj which he is talking about here. Now, Malus, one page, Your Lordship, I forgot about this complainant. 39 of the CC. I stopped at 35. Just note 39 also, Malus. Just 3 lines I forgot to show of that complainant. One sentence there is important in the middle of 39. I'm sorry, I forgot this page. Middle. It is true that there's a complainant. It is true that my surname is appearing in disparaging remarks made by the accused. But my individual name as Purnesh Modi is not appearing in it. Well, as whatever else the accused fault might be, He never dreamt of Purnesh Modi when he made this statement. He had no idea who Purnesh Modi was. Now, just two things that I am done, Malus, on this point. First, come to Malus, how it is dealt with. Is this a fair way of dealing with it? Is my question to myself at page 67 of the Learned Sessions Code. It's a perfunctory way of dealing with it. It is a way which means that you have touched it without dealing with it at all. C67 of the Sessions Code, the impugned order. The learned advocate, Mr. Chima, drew the attention of the court to 199. I'm reading the middle, Malus, double I, page 67. Paper book, main paper book. I'm sorry. The main paper book. The learned advocate, our side, drew the attention of the court to section 199, submitted the complainant cannot be termed as an agreed person and hence was not authorized to file the complaint. Further stated the expression Modi propounded by the complainant do not fall in the category of association, etc. Same point is made, it is further submitted as per complaint's assertion, cost to 13 crore. That sentence itself is enough. If a class is a general class of 13 crore people without any identification, it can't be a determinate class. Submitted the association correction cannot embrace a large population which is identified, not a definite or identifiable group. Learned senior advocate by drawing attention towards evidence. This, well, I'll skip. All this evidence is stated. It is last 4 lines. It is submitted from the evidence of above. The concept of expression Modi being an association of persons becomes entirely unacceptable. It is submitted the complaint was filed with a political motive. The learned senior advocate is relied upon. Now, all those cases are listed by Mr. Chima at page 68. 3 of them are important. I have read Malus, and Khushbu also is somewhat important. After the cases, Malus, I have gone through all the above. This is the totality of the dealing. Just see where is fair, Malus. Where it is held, collection of persons must be an identifiable body. So it's possible to say with definite a group of particular persons as distinguished from the rest of the community was defamed. Moreover, an identity of collection of persons is not established so as to be relatable to defamatory words or imputation. The complaint is not maintainable. It is further held there cannot be defamation against the community or such. Community as such may not have a reputation. Only the reputation may be of individual members. Then was 69. Come to para 5 at 69. This is the totality of how it is dealt with. I am mindful at this stage, if I deal with the above issues in detail, then it would cause prejudice. Then at any point I argue to say that it's a very strong case I have. It's a very strong, your lordship's test is prima facie case. Exceptional case. How do I make a prima facie case? Any case I make, your lordship will then be told that if I opine upon it, then I am opining. No, your lordship always says at the end, my opinion here is tentative only for purpose of 389. It doesn't mean I can't be convicted again, doesn't mean I can't be acquitted again. But this paragraph unfortunately has that error, clear error. However, looking to prima facie evidence and observations in impugned judgment, it transpires that the appellant had made certain derogatory remarks against Honorable Prime Minister Shri Modi in general public, further compared the persons having Modi surname with thieves, and the complainant is also having the surname of Modi. Just pause here. The defamation of the Honorable Prime Minister is not involved because he is not a complainant. Certainly he is an identified person. The next sentence is the defamation. And further compared the persons having Modi's surname and the complainant is also having surname of Modi. That is 1 out of 13 crore people. It is that which is defamation. That can't be identifiable class. Moreover, now this moreover is completely unnecessary. It's completely surplusage, conjecture. It's irrelevant to the law of defamation we're discussing. Completely. This would be relevant if I said Mr. Purneshwar Modi by name. It would be relevant. And he said, just I read page 39. He said, my name is not taken. The accused has not mentioned me. I am not identified. But yet, see the error. So there are 2 errors in para 5. The complaint is, moreover, the complainant is ex-minister and involved in public life, and such defamatory remarks have certainly harmed his reputation, would have certainly harmed his reputation and caused him pain and agony in society. This will apply equally the same degree of harm to Mr. Purneshwar Modi, if this sentence is correct, will apply to each one of those 13 crore people. If that is so, then please accept it, but do not have sections like 499 and 199. Then you can't, the meaningless will the section. The next point is, the somewhat serious facets of trial vitiation. And I'll highlight 4 or 5 immediately. Very serious. A separate one within those 4 or 5 is 202, which I'll come to separately. But what are those 4 or 5 matters of trial vitiation? Number 1. So I'll give 5 very clear ones. Or rather 4 maybe 4. And the 5th one is 202. Well, 2 of them are ex facie 2 plus 2 is equal to 5 errors. On the face of it. They are related. The 2 are related. What is it, The learned judge, says he bases his sentence. He bases his case against me by saying that, look, Mr. Singhvi, you were warned or admonished by the Supreme Court in the Rafael case. And you had to be more careful. And therefore, because you were warned there, your error here today is more egregious. This is a direct finding at page 567, para 4. So this is the entire basis of sentence. So see the 4th line, further in connection with the case of SLP so-and-so before the Honorable Supreme Court. I had appeared here, in the main matter. This is the Supreme Court matter. The accused had sought for the clemency in writing, and the Honorable Supreme Court had admonished him to remain alert in future. Though the accused has committed this offence, further, etc., if he is imposed lighter punishment, will set false example in society. Right, fellas? Now just note that 2 plus 2 is 5 error. This caution in the Rafael judgment, where the present accused was let off from contempt, is dated 26/11/19. Kindly note the date once.
14/11.
No. Order of Justice Gova is what?
14/11/20.
You said 26, you said. I'm sorry, a correction was 14/11. That is the judgment of the Honorable Supreme Court, 14/11, not 26. It is common ground that the allegedly offending speech in today's case was made 7 months earlier on 13/4/19. Kindly note that date also, 13/4/19. Now, this is a clear error apparent because there is no question of being retrospectively careful. This speech in Kolar, Karnataka happened on 13/4/19. The admonition came 7 months later. So clearly, the learned judge misdirects himself. And it is at page 567. Note one more page, in the same volume, in my written submissions, I vehemently took this point of the error at page 671. I said this is a direct error. That's one part of the clear approach to the trial, approach to the sentence, the vitiating factors, why my confidence is shaken in the trial, in the conviction, in the sentence. The second related point is to this, that we are in criminal law. We are not doing some kind of a writ petition or just some affidavit filing. In criminal law, anything and everything, why does the Lordship go to such extent to say, prove the document, show the document, confront the person, put it to him? That's the whole system of criminal law. Sometimes I find it cumbersome, but that's the law. Biggest murder convictions are disturbed on these. Here, this entirety of the Supreme Court reference being the basis for sentencing. None of the Supreme Court, including the order or the record, was put to the accused. In particular, so Malus, because it is admitted that the sentencing is done within 10 minutes on the same day. That is 23rd of March. Same day, shortly thereafter. As a matter of fact, had you put it to me, possibly a mistake would not have occurred. But that's a separate point. First point is, Malus, under criminal law, you cannot arrive at conclusions without A, verifying. You to put the order, you to in fact prove the order to be very clear, and then confront. None is done. That's point number 2. Point number 3 is more serious. And Malus, I raised this point again in my written submission in the appeal court. That is your lordship's court below, Malus. This is the error by the magistrate. My learned friend has got the entire written submissions here, vehemently raised. The sessions court has ignored this point altogether, that you relied on a backdated event, not backdated, a prior event for a subsequent Supreme Court order. And then when I raised the point, the magistrate hasn't dealt with it correctly. The magistrate never gave me an opportunity to deal with it. You, the sessions court, should deal with it. The sessions court did not deal with it at all. Then, Malus, the third point is more serious. On the date when summoning order was issued, 2/5/19, summoning order is 2/5/19. Malus, your lordship knows that the bedrock of all criminal proceedings is the summoning order, or most criminal proceedings. It's the trigger, Malus. It's the basis. On that day, when you look at a matter, because my lordship has 100 cases, don't set the criminal law in motion so easily, don't harass him. It's a tedious process, not just sending some summons in a civil matter. It has consequences, reputation, harassment, blah, blah, exemption seeking, presence in court, etc., bail sometimes. So, all that wisdom, which your lordships have said, be very careful in the summoning. Summoning order is the bedrock. Now, this was issued on 2/5/19. The point I'm making is that on 2/5/19, the Honorable Magistrate had no, I repeat, zero prosecutable evidence before him. Zero. There's no way he could issue summons, Malus. Why could he not issue summons, Malus? The bedrock of the bedrock. I said the summons is the bedrock, Malus. But the bedrock underlying the summons has to be, Malus, the speech. This whole case is about a speech. On that day, when summons was issued, there was no prosecutable evidence for 3 or 4 simple, obvious reasons. 1, the person who complained was not the audience admitted. He did not say that I was sitting here and hearing Mr. Singhvi speak. 2, his whole case was, I'm talking about 2/5/19.
Yes.
That I, the complainant, received a WhatsApp which had a account of that speech, which is a newspaper report of that address. That's it. On the day of summons, the WhatsApp is not proved. WhatsApp in any case is hearsay. I get something on my WhatsApp, I can't prove it. I have to get the source which sends me the WhatsApp. The sender is not disclosed. Unidentified. Not known to the recipient, the complainant. Obviously, he has to be known. The only thing is he doesn't want to reveal his name, because how can I receive a WhatsApp without knowing who's sending it? No, something don't be very up like this. Now, there is on that day no pen drive. Nothing. It is hearsay upon hearsay upon hearsay on stilts, as they say. Shakespeare used the phrase, nonsense upon stilts. This is hearsay upon stilts. No YouTube, no pen drive. All that comes 2 years later, We are not concerned with that. We are talking of the serious vitiation of the trial. How on earth can a prosecutable situation arise for me to issue summons? It cannot. This is admitted. What is amazing is turn to page 30 of Your Lordship's CC. I mean, what is worse is it is admitted. Nothing is left to the imagination. May I read it, brothers? 30. Middle. Bang in the middle, brothers. It is, may I read the previous sentence? I have not stated anything in my complaint about the fact of YouTube channel as stated in my deposition. You are issuing summons only on the complaint stage with some minor looking here and there. It is true that I was having WhatsApp message at that time of lodging complaint. It is true that I was not having disputed speech at the time of lodging complaint. But only message was received in WhatsApp, and the magistrate can't issue summons. Well, what's the point of the Lordship has got so many judgments saying, be careful, be hesitant. It is not true that it can be known after hearing the entire speech, whether any speech is defamatory or not. It is true that I cannot state as to how many persons wrote the speech at the place of speech and who gave the said write-up or recording. I cannot state as to whether the speech has passed through how many electronic devices before it reached the YouTube channel or election commission. But in criminal law, the slightest possibility of doctoring, Your Lordship eliminates first. Even though you see, I saw it, you say, please send it to forensic first. Here we are talking 2 years later, on that day he is admitting, he had nothing. Well, on the top of the same page, this, because the Lordship in this case is going to hear pen drive, YouTube, that is all happening much later. We are talking of prosecutable evidence, date of summons. Now, let us see the 6th line at page 30 itself, above what I have read. It is true that I have not submitted pen drive produced by 21. So the exhibit 21 all is much later. Nor compact disc produced with exhibit 26 at the time of lodging complaint. It is true that I have submitted copy of newspaper regarding news of speech along with my complaint. That's the WhatsApp message I received. That's all. Now, brothers, on that day, my third point is therefore, these are not methods and manners of issuing summons. Brothers, the speech is on 13th of April. In newspaper cutting is done. Note, brothers, 2 dates more. On 14th April, I am told that he files. 1 day later. This is, you can't set in motion the criminal law like this. And on 15th of April, the statement is recorded. Sorry, verified. Yes. On 15th. 15th is it? I see. I'm sorry. So it's 1 day later. 15th is the complaint. 16th is the verification. But I'm wrong by 1 day. Then, Manoj, my fourth point is something even more serious. It shakes the confidence of a accused, but also the system in the purity or the probity of the trial. That's my fourth point. I made 3 points for us: the speech, the Supreme Court point, the non-confrontation point, and the prosecutable evidence point. Now the fourth point is, brothers, and this is even more serious. You have today then reached a stage with me on the date of summons, there is no prosecutable evidence. Separately, I am going to be arguing, I have not reached it yet, that you have never proved by either Evidence Act or the IT Act, nor are you a witness, nor is that reporter a witness, nor has anybody else evidence been proved. That's a separate point, keep it aside. But what happened, Manoj, is that having not proved the speech, he, Manoj, produces after 2 313 statements have been recorded. Note the date of not one but 2 313 statements, because these dates are important, Manoj. 24/6/21 is the first 313 statement recorded.
21st.
24th June 2021. Now remember, Manoj, we have crossed, your lordship started this in April 2019 with zero evidence. You are now getting 313 on 24/6/21. And the second one is on 29/10/21. This is full 2.5 years later. 29/10. These statements are over. He realizes that he has no evidence worth the name. So, brothers, he files an application on 23rd of February 2022 in the trial court, saying, you, the trial court, kindly allow reopening of the evidence, in particular by playing the pen drive which I have now filed in 2021, 2 years later, and some YouTube CDs, two things. Play them to the accused Mr. Singhvi to get some evidence of whatever lordship calls reaction, etc. to record it. This application he files on 23rd of February 2022. Rightly, whereas the trial court records reasons and rejects it on the same day, 23 February 2022, and just glance at the reason at page 159 of volume 1, the paper book. The trial court basically says, the ship has sailed, we are very late now, everything has happened, 313 has been recorded, what are you doing? I can't reopen at your request. That's what the trial court is saying in a nutshell. Come to 159 bottom, para 4. Third line, para 4, 159 of the volume. I am not on the merits. I am saying my confidence is shaken in the trial. Look at these events happening. Just see this, what happens, brothers. It is prayed. May I read the third line? So the learned trial court is summarizing his application. It is prayed is by Mr. Nanavati's client. It is prayed before this court that considering the evidence and facts brought before this court should give fresh opportunity to the accused to seek explanation, that is, confront him. If the facts mentioned in the present application is looked at, it is prayed that the accused summoned shall be confronted with the questions in connection with that which is produced, namely pen drive, etc. Basically, it's pen drive and YouTube CDs. In this view, now he's deciding. In this view, the statement recorded already of accused under 313 is looked at. Specific questions with regard to exhibit 21 and 26 and the CDs and pen drives have already been put. This was a dilatory tactic, nothing but what he had to put, he had put. This was some kind of a game being played and a serious dilatory tactic, causing great prejudice and suspicion. And he must have decided not to play the electronic record that time, because there will be no proof till then. Then 313 was something which is already on the proof basis, has to be, so he knew that somebody raised objection. This is an afterthought to delay things and suddenly accelerate it. I'll just show that. Specific questions with regard have already been put. Specific question with regard to the evidence brought on record to light have already also been asked. Now see the next sentence. It appears to this court that there is no any other or further important questions left out to be asked. The court further finds there is no defect in the statement. This court does not find it just and proper to summon the accused again and to confront him with his further questions in relation to the produced CD, pen drive, etc. Last para 161 rejected. This is not what I am pointing out. This is itself serious, that you are knowing it. It was there with you before. Did not do it. Now, against this, he rushes to the 482 to the High Court and gets a stay on 7th of March 2022. Need not go to it. It's at 186, the order. Against his own fault, his own afterthought, his own delay, he goes to the High Court and gets the stay of his own trial, where he is the prosecutor, or the complainant at least. That's given on 7th of March 22. Now note one thing, 7th of March is only last year. From 7th of March to 16th of February this year, everything is hunky-dory. The complainant is happy with his own stay and he stayed the trial. But more importantly, from 7th of March 22 to 16th of February 23, nothing has changed. There is no new CD, there is no new speech, there is no new witness, there is no new paper, there is no new photograph, there is no new recording, there is nothing has happened. 1 year, exactly 1 year. On 16 to 23, he suddenly, and that will remain an eternal mystery, although I have lots and lots of guesses, he goes and seeks a vacation of his own stay to activate. And meanwhile, I forgot to give one date, I'm sorry. After 7th of March, one important date I forgot was before that. 4th of March, he's creating a ground. I'm sorry, 7th March, he went to the High Court, or she got that date. I forgot to give a date before that, 4th of March, 3 days before. This is unacceptable. It's clearly some kind of a grand scheme. He creates a fight in the court, trial court, to enable him to go to the High Court. He tells the court that I will not come to your court. The court says it's a part-heard matter, we have to finish it. He then tells the court, yours is not the only court where I have to appear. There are other works I have, other courts. And he then leaves the court in midstream. And then, his right to argue further stands closed. Every word of this is recorded on 4th of March 22. I don't have the page. It is separately, in your Lordship's file. The order sheet. The daily Rojnama has it. Your Lordship knows Gujarati, I don't. Your Lordship can read it. Not here. Your Lordship. We can give your Lordship as courtmaster, the Rojnama. But on 4th of March, just these dates, I'm sorry I missed out. The dates are 23rd of February, you move this. Sorry, 24th of June, 21, the 313 is recorded. 29th of October, the second 312 is recorded. 23rd February, you file an application. Your evidence is closed on 25/2. Actually, first time it was closed on 25/2. At your request, it is reopened on 28/2/22. Having reopened it on 4th of March, 5 days later, you create a fracas and a scene in court which is recorded in Gujarati here. Exactly this I have told your Lordships. Yours is not the only court I'll argue. I've got other work to do. I'm walking out. I'm telling my junior to take my, also recorded. I'll take my junior to take my file away. And in effect, with great respect, saying, I don't care. The court then closes it. Take my word for it, don't read it now. Your Lordship will be able to see it. I've examined it, with those who know Gujarati. This is 4th of March. On 7th of March, he goes to the High Court and gets a stay. Now comes my final point. From 7th of March for 1 year, no new fact, no new cause of action, nothing new happens. On 16th of February 23, not 22, 23, he suddenly withdraws, comes running back to the trial court. The whole matter is argued and judgment comes in less than a month. The trial and the conviction is over in less than a month. Effectively, there was no trial prior to that. These dates are seeming long. There is nothing happening. You have stayed your own complaint. You have stayed your own trial as a complainant. The 5th point, is the point about 202. That's important. The 16.2 order gives what our Lordship knows as a fig leaf. Because I have to give an excuse. Whereas I get a stay from your Lordships. I keep it pending here. 1 year later, I come running to you. Please allow me to withdraw my petition on which your Lordship is given a stay. Whereas normally, I would say that people who are very particular would say, okay, first show me why. Otherwise, I'm going to impose costs for taking 1 year of the court's time by clogging up mine. Now, what is the excuse he gives? Is a fig leaf of an excuse. The reason, give a copy to my lords. Give a copy. What he says here is, appearing submitting that sufficient evidence has come on record of the trial court and the pendency of the matter delays the trial. And see, what is the evidence? Nothing has come. Nothing has come. The first sentence is itself, not a comma, full stop has come. What was insufficient evidence 1 year ago has become sufficient evidence. Hence, he seeks permission to withdraw at this stage, leaving all contentions open. Permission as prayed for is granted. My advocate, Mr. Chapari, this side is opposes the statement, etc., etc. We will disprove the statement. But there is nothing there which has changed. The record is the same. We have to have the record. And nothing can change. It is a fairly advanced stage. 313 was over. Your right to argue, you had destroyed yourself. What can change, Wallace? Now, Wallace, 202, the point is, let me summarize the point, Wallace. Your Lordship is well aware of 202. Let me first give your Lordship, then I'll only read two portions to make it quicker. The point here is number one. 202 was created by an amendment. It was not there always in this form. And the underlying material before 202 said, you have to have it as a mandatory requirement because of preventing or minimizing abuse of process. And it was classically made for cases like ours, of Kolar versus Surat. Classically, it was made for that. I'll just read one, then it will become clear. Having amended the law by amendment and inserted it, a debate arose whether it is mandatory or half compliable or directory, or you should try to comply but you can ignore it. That debate was settled in several cases. The particular one is Dhanuka's case, which is followed in many cases, that look, it is mandatory. So that's point number two. Held, so the first, the rationale underlying the amendment, this is an abuse, something happens there and you come to Surat to do it, please have an inquiry. Second, is it mandatory or not? Settled, it is mandatory. Third, flowing from mandatory itself, it's an interpretation, it's only an inference, but it's an established inference. If something is mandatory and I raise it today or I raise it 2 weeks later or I raise it late, it will make no difference because your lordships have to take the bar itself even if I don't raise it at all. Suppose I don't raise it. Well, suppose I don't raise, but your lordship is staring in the face limitation. Lordship, you didn't raise it, I won't touch it. That's not the law. When judgments have held it to be mandatory, irrespective whether you raise it or not, you are the court, you are obliged to take it. That's point number 3. Point number 4, the trial court bullets records various submissions, but these are in one sentence that you raised it late at the time of hearing, final hearing. That's the only point. That cannot be if it's mandatory, Maras. Whether you raise it or not, you are. And he then cites one para again and again. After verification, seeing the file, looking at everything, I've issued summons. And the learned judge, magistrate, and more importantly, the sessions court says that is sufficient application of mine. So the fourth point is, Maras, the sessions court commits a clear 2 plus 2 is equal to 6 error again here on this count. What it does is, Maras, just note, at volume 1, page 73, don't go to it now, just note the point, Maras. At 73, the sessions court underlines a passage in a case called Sunil Todi, saying that this passage suggests that it is not mandatory. Now, Dhanuka is anyway against it, it's clearly. But what the learned sessions court makes a clear 2 plus 2 is 5 error is that what he underlines, saying it is from Todi which holds is not mandatory, is not a passage from Todi at all. It is a passage from another constitution bench of the Supreme Court, totally different case, which held that there may be some debate earlier that under 138, only 138, check bouncing, it may or may not be mandatory. But we, the constitution bench, hold that it is mandatory. There is a debate between this case and this case, which says in 138, he says it's not mandatory, he says it's mandatory. So the constitution bench had to iron it out. There also they held it to be mandatory. The learned judge underlines and misreads this to say, this suggests it's not mandatory. It's completely wrong. So this error by itself, brothers, The first error of the learned trial court is there is no inquiry. There is one malas delightfully vague para, having considered all the papers, verified, I proceed. That's not malas. 202 doesn't require a judgment, no doubt, but 202 doesn't require that having seen the papers and summoned the witness, automatically 202 is complied with. Where is the inquiry, malas? Whom have you said? Did you send any constable for inquiry? Did you send any, you can do anything you like, and the inquiry can be many forms. Where is the inquiry? Nothing. The only sentence then given, knowing that that is wrong, is that you came late. So these are 6 errors, which are serious. And this is sufficient as the 6th point to vitiate the trial. These are all matters which will be bound to succeed according to me in the trial, in the appeal court. Therefore, I need an interim protection. Now, what are those pages? Well, just see very quickly. The error occurs firstly at 73. Well, this system everywhere in the judgment is underlining what I am relying upon. That's what he does. This is kind of way of putting a finding with the learned judge. Now 73. Well, this para 10 is what he relies upon. Just note para 10. And your lordship may note on the side, this is not Todi at all. This is a extract, para 10, just I have to go a little slowly here. Para 10 at page 73 is para 10 of a constitution bench. But it forms part of para 45 of Todi. Because Todi has quoted another constitution bench is point 1. Point 2. It clearly holds it, Willis, in the actual judgment if your lordship goes to Todi. Page? Same?
Yes. Judgment compilation.
Kindly go to 183 of judgment's compilation. Where is? Starting page?
183.
183. I'm grateful. One second. 183 first. So it starts at 183, come to 195 straight away.
Yes.
There it becomes clear what is Todi, what is non-Todi. Well, at 195, your lordship has got the same para reproduced. And then, Wallace, para 45 starts at 195 lower part. And your lordship sees the first line regarding expeditious trial of Negotiable Instruments Act 188. Sorry, 1881. That is well as the context. And then if your lordship continues after 45, he quotes that constitution bench. And even the constitution bench says that ultimately in para 11, the next para at 196, that there are two views. We will accept the amicus curiae suggestion that even in 138 should be mandatory. That's the end of para 11. The learned, that's my lord, the last line of para 11.
Yes.
The learned amicus curiae recommended that the magistrate should come to a conclusion after holding an inquiry that there are sufficient grounds to proceed against the accused. We are in agreement with the learned amici. So clearly, Maluts, that judgment approach in the sessions court is wrong. And just note the paras of Todi which hold it to be mandatory. Para 38 at 193 and para 39 at 194. Please take my word for it. It holds it to be mandatory. Para 38 and 39. Yeah. 38, 39 is direct finding. 38, 39 is a direct finding. Now note below Vijay Dhanuka, which is the main judgment followed everywhere. 201 and para 12 is clear at 207. I'm saving time not reading it. Your Lordship is only concerned mandatory holding in the para. Holds it to be mandatory at 207 para 12. It says the words are shall. It says there is a law commission report. It was amended. Shall, well, it says in the lower part, shall can mean may, but here shall means shall. In one line, that is the summary. Para 12. Then, Malats, the only basis, one more case is very important, the little noticed case, very important. Pawar's case. Pawar says that because it is mandatory, it doesn't matter when, even you can raise it for the first time after 2 appeals in the High Court. That is Pawar. So the other compilation.
It's in the other compilation.
Well, I'm sorry, this one was left out, so it is put in the other compilation. Show me.
I'll just give you. Page 106, 109, para 23.
Page 106 at 109. I'm sorry.
106 and 109. para
I see both.
23.
106 was para 23. Where is Pawar?
So it's many.
Oh, I see. Just give me a minute, I'm sorry. It'll add. Abhijit Pawar was added later on. That's why I'm missing it.
Admitted position and laws.
Now, let us know where it says to go to High Court also. Well, para 23 at 106 starts the vital necessity at 10. Then 24 is Vijay Dhanuka. And then, Malus, just see.
Again 26 also Vijay Dhanuka reference.
And then see, Malus, 30 is the important para. I was looking for that. Of course, you should raise it early. But if you fail to raise it, just see 30. 30 is all that I'm interested in, because the only ground given against me is that even in the High Court could have considered this argument on merits. Then middle sentence is 30. So where you have failed to, because it's so important mandatory, you should. Here, Manus, who has considered it? Now see, Manus, how the Sessions Court has dealt with it. The only reason given is, first see the magistrate, Manus, and then see the Sessions Court. See the magistrate. Just give me the Sessions Court, because Sessions Court has dealt with the magistrate. Just give me the Sessions Court.
73.
Sessions Court says two things. One, the High Court, the magistrate has dealt with it inter alia because you came late. More importantly, it quotes the magistrate same para 5 times, 3 times. That the magistrate said, I have applied my mind.
75.
Up to
Verification
75.
was done.
The only mind that Paisa applies is use of formula words, giving my thoughtful consideration to all the materials, verifying the complaint, etc., getting the statement and reading the complaint, I am issued. No mention of inquiry. Where is the inquiry has to have something. I'm not saying that your Lordship will put up a board saying inquiry, invite objections, have a commission of inquiry. Something has to be done to go somewhere. Now see, based on the above, it's 75. It transpires that the magistrate, after the thoughtful consideration, verification, and subsequent proceeding, should never challenge at any stage. Hence, the objection is being vitiated due to lack of clarity can be accepted. Then was the other part of this. Another part. Show the magistrate where it is. Show the magistrate. Show the magistrate here. I'm sorry, but just give me a minute.
Conviction notice.
The magistrate page.
Magistrate.
Yes. As the Lordship leave it, I just show the magistrate page. repeated that formula words again and again. I'll just come to it. My next, so I conclude on 202 saying there is otherwise a clear vitiation. The answer given is it's late, but the more particular answer given is the other formula words I've used, therefore it's deemed that I applied my mind. There is no evidence of inquiry, therefore it is clearly wrong. I raise it before the sessions court, no answer except page 75. That's the answer. Then no documentary proof of speech is in that sense my last point in terms of the merits. That is clear.
So paras are 20.1 to 20.
I'm sorry, this is a little late in coming.
20.1.
This is at page 535,
Para 20.
20.1 onwards. Yes.
And it goes on till 20.3.
531.
Yes.
I'm grateful.
Yes.
When you feel it's in 20.3,
Yes.
then I won't accept.
This is the entire case on 202. So Lordship will read to 20.1
Yes.
and then come to page 536 over the page.
Yes.
Whereas in the present case, the order of process is not challenged by the accused in the apex court till date. In the present case, the entire trial and the conclusion issue has been raised at the stage of argument. In the above judgment, defense has been raised, not order the case, the procedure shall be vitiated. This I have just read Pawar Balu, which says even the High Court level it can be raised. And then 540 is 20.3. As per the principle laid down the above judgment, if inquiry is not conducted, trial is not vitiated, defense could not show what prejudice, etc. This is the totality, and he says basically that I have applied my mind generally to all the papers. But it is clear, therefore, that inquiry, even the judgment suggests inquiry has not been done. It's blaming me for not taking it to the apex court. Now, I come to this documentary proof not existing. Just note in simple form what the issue was. Now I am on the proving of the one part is that on the date you had no prosecutable evidence. Now on the date of conviction, you had no admissible evidence. That was on vitiating. Today, how do you convict in criminal law on this? On criminal law, you can't convict whether on an affidavit or on my say so. What is this point? Well, just note, I'll break it up. First point.
Yes.
WhatsApp cutting has not been proved. And on instructions, I say it has not even been exhibited.
No.
I'm breaking it up. Bullets, about 10 bullets will be there.
Yes.
But we'll just see. WhatsApp is not exhibited, not proved.
Not true.
The entire basis is the WhatsApp. The pen drive, exhibit 21, not produced with the complaint. No mention of the pen drive in the complaint. It comes over 1 year later, around November 2020. And it is exhibited subject to a caveat. Your Lordship sometimes does it, but says clearly, subject to on the condition of proving it. Never proved. So exhibit is irrelevant. I would call it not exhibited. But if your Lordship exhibits something saying subject to it being proved, and you don't bring any proof till the end, it amounts to be not exhibited. It is not exhibited. And trial is over, I am convicted. The entire basis is only twofold. One is whether this person can maintain a complaint. Second is on the basis of a speech which is on a WhatsApp. There is no pen drive, not exhibited. Then fourth, there is no 65B certificate. Well, it sounds like something technical. No, the very important thing, Your Lordship, is upturning big matters. No 65B certificate to support the recording.
Has to be at the time of production.
Then, that's why I say something very interesting happens. A miracle man appears. Now we come to CDs. Now CD suddenly appears from the Election Commission. And the story is that Election Commission gave it to a miracle witness called Yaji. I'll tell you why the miracle witness. This Yaji Malas admits in writing at page 44 of the CC that I am heavily involved and office bearer of very important positions at the local level in the BJP. And a close friend of the complainant, he says it, these are not my words, and operating with him in all this. Because you know that till 2021 you have no proof, you suddenly in desperation produce this Yaji. Yaji Malus is directly, intimately connected with the complainant. It is as good as the complainant himself saying, there's no difference. And he becomes the sole basis and nothing else of Malus supposedly verifying the entire element, contents of the complaint. Yaji is admittedly not named in the complaint. He is not born in the list of witnesses. In fact, he is not present till the late 2020 or early 21, 2 years later. So, Malas, the totality of all this is Yaji. No WhatsApp, no pen drive exhibited, a CD appearing 2 years later, not verified, only person is Yaji. Now see two parts of Yaji first. Come to CC1, page 44. Can this witness be a basis of my conviction, Malas?
Two more things he admits. He admits that he didn't get CDs in a sealed condition. That's point number one. And second, he admits that cross-examination cannot be ruled out.
As your lordship reads with me this Yaji, two things. Ganesh Yaji.
Exhibit 67.
What is PW?
No,
This is page 44, Malas.
So they give exhibit
Referred to
number.
by name and
Your lordship gives exhibit numbers apparently. The exhibit, it's page 44 of the CC1. Let's use that one, of the compilation. Now, well, this totality is important. Well, Yaji is, I am sorry to repeat, is very important. Yaji is A, brought in, not in the complaint. B, not in the list of witnesses. C, comes almost 2 years later. D, is a complete close associate of the complainant and holding official positions in the BJP. E, well, in all such matters, your lordship has to have clearly some clear evidence of non-tampering from something which came from the election commission, came to my hand. There was so much tampering. There is a statement that tampering by him, that tampering can't be ruled out. And there's no other proof apart from this Yaji CD because there's nothing in the WhatsApp. On these points, just turn to page 44. At present, I am cultural advisor, lower part, of the Chief Minister of Karnataka. In the year 2019, I was regional director in the BJP. I did not know the position of regional director was. Generally, in the regional office, I am supposed to convey the instructions coming from the BJP center office to district and taluka levels and to execute such instructions, and to submit a report to the regional and central office. The last Lok Sabha elections were held in the year 19. At that time, my duty as a regional director, and since the Lok Sabha elections were ensuing, I was given some extra work from the party. Various departments like tourism department, legal department, publicity, material distribution department, and my duty was to carry out liaison working from the representative of the party with such department. Pretty large canvas. Come down below to the same page. Apart from the aforementioned responsibility, I was instructed to attend a lot of public meetings in the year. That year is wrongly typed. 2021, I think.
2019.
Oh, I see. This is wrongly. 2019. That typo will be corrected. It's 2019. A public meeting of our national president of BJP was held during 2019 Lok Sabha election at Honali, and I had performed the duty to attend such meeting and to carry out translation work of the lecture given by Shri Amit Shah in Hindi into Kannada language and hand it over to the regional office. One public meeting of the then president of the Indian National Congress, held at Kolar, on 13th April, where I was supposed to attend the said meeting and hear the issues upon which Shri Rahul Gandhi gave speech in the said meeting and to submit a report. On that day, I had left from Bangalore, etc. Then he goes off. Okay. Kindly, so this is only for the positions he holds. I'm not good. Now note, Balas, how I deal with the whole thing at one place. At 665 is my written submission. And it can't be ruled out. Ruled out. I'm sorry, but it's 56 also before Lordship leaves it. 56. Last line of 56, the ruled out thing. Rahul Gandhi had said bottom in that speech. After that was right at the bottom. Right at the bottom of 56. The CD bearing 26 does not cover the entire speech of Rahul Gandhi. And then was how much, next page, total how much speech of Rahul Gandhi has been left out in the CD. Some sentences have been left out in all the three CDs. Can't be ruled out. Tempering, where is that? Then tampering was some suspicion raised because he says it was lying in open condition at page 52. It's not sealed, it is not sanitized. See the bottom of 52. Find out. Can't be ruled out. It is true, bottom of 52. It is true that I received this CD in open condition. Mark the word open condition from the Election Commission. I had not stated election, given me this CD, etc. I'll give the exact sentence where about at fourth line was, I am not aware as to from where the Election Commission obtained it and made it. It is true that I have not seen the original CD lying with the Election Commission. It is true that I handed over the CDs being exhibit so-and-so to Raghunathan in the same condition as I received. Then again he says open condition, 4 lines later. Received them in open condition. And then next para he says in page 10, I am associated with BJP for 45 years. It is true that since I am senior, I have been given various designations. I was secretary of BJP regional office, and then he goes on with this, cultural advisor, etc. Now, my summary, you will note. I mean, I don't want to. At 665 is my summary of volume 1 of the main volume, 665.
Yes.
Because we are now on proving the document in any of the 3 ways. 3 ways. Which way have you proved it is for your lordships to consider. Prima facie. No way have you proved it. 665. Para small Roman 2. In the detailed grounds of appeal of these submissions have been summarized. Second sentence in II. It is the clear and concise case of the appellant that the following documents electronic record was never proved in accordance with the law. Therefore, the complainant is not entitled to refer to this material to prove the contents. The complainant miserably failed to prove the cutting of the newspaper, forming the very foundation of the complaint, which he claims to have received on WhatsApp message and pen drive, incorporating the same in accordance with law. In fact, the complaint in question could not have been entertained at all on the basis of this material. Further, the complainant has miserably failed to prove the content of 3 CDs, marked as 26, statedly obtained from the Election Commission. Further stated that 3 DVDs marked as 126 remain unproved. The next paragraph. The documents were marked only for purpose of identification, subject to the condition. It's as good as not exhibiting. Subject to the condition makes it clear it's not exhibited. This issue is further required to be examined in the light of the fact complainant took the issue to the High Court with a prayer for examination of additional witnesses. It is after this exercise that DVDs were brought on record. They still remained unproved. Significantly, this complainant went to the High Court again because it agreed by additional trial court, declining the prayer to put, I saw that order, put the contents of the electronic documents as having not been proved. In this regard, an exchequer giving the details of the petition. Lordship remembers 4th of March, he went to the High Court, he said to confront me with all that. High Court, that matter was pending, the trial court had said no, we can't confront. It is therefore crystal clear that the documents referred to above have not been brought on record in accordance with law. It is for this reason the contents by playing the devices were not put to the appellant. The escape route of relying upon the so-called admissions made in the statement is patently misconceived. A bare reading of 313 makes the factual situation patently clear. No point of time did the appellant in any manner except that the so-called incriminating material formed part of the speech delivered by him at Kolar. The judgment cited is patently inapplicable. Now, let us see B. B is the Yaji point. Faced with this impasse, in utter desperation, the complainant examined a veteran party man, Sri Yaji, Exhibit 67, as a witness claiming to have heard the speech. Though this witness had been associated with the proceedings from an early stage, it was never whispered that he had attended the meeting in question and heard the speech. That's why I call him a magical miracle man. This witness appeared in court after a long delay of 2020. Well, this is 2 years afterwards. He therefore claimed to exactly remember the contents of the oral speech heard by him time back. He failed to prove that he had prepared any written note or report of what he had heard. Detailed grounds in this regard are found from 55 to 57 of the memorandum. Oh, I'm sorry. I'll take a very short while after. Very, very short while. DP of life.
Before my, let 2-3 matters, yes, after that we can proceed.
May I request to mention it? I am requesting for circulation of criminal appeal to the press. Since 10 days I have filed, but
Yes.
office notice not placing on point.
Why?
Unless
If
court
there is any-
permits me, Lord, it will not be listed.
If there is any office objection.
No
is-
objection. Without any objection. Please.
Tuesday.
Choose, please, always.
Pass over matters. Serial number 2. Ms. Jayashree Bhatt, learned public.
Yes,
Yes, ma'am.
here regarding my lord temporary bail on the ground of sister's marriage. My lord.
Yes.
The marriage is going to be performed on 2nd May, my lord. Ceremony starts from today, my lord.
After conviction only 11 months and he is
year.
convicted for the offense punishable under section 489
7
306. No case is made out.
My lords are not inclined to
Yes, I am not.
permitted to.
Serial number 3. Part in person, Chetan Kumar Thakur through Tarap Thakur.
બોલો લગ્નમાં ઘણા બધા છે કુટુંબીઓ કન્વિક્શન હજી હમણાં જ થયું છે ખાલી 11 મહિના જ થયા છે જેલમાં આ લગ્ન છે બીજા ઘરના એના સગા આ તમારા ભાઈના નથી બાકીના ઘણા બધા માણસો છે પરિવારમાં આખું લિસ્ટ બનાવ્યું છે તમે પરિવારના સભ્યોનું applicant is convicted for the offence punishable under section 363 read with section 6 of the PORTEL for a period of 10 years and only 11 months he is actually undergo as a prisoner. No case is made out. Application rejected.
Serial number 8. Mr. Sandeep Limbani, learned
ભાઈ આમને
ના મંજૂર કર્યા.
Twice the matter is called up. The learned counsel will remain present and in the interest of ત્રીજી કે ચોથી તારીખે રાખો.
4th of May. For court board, serial number 1, Mr. Anil Rathod, learned public prosecutor.
Yes, Mr.
exceed for 647.
Yes.
On the ground of the petitioner lawfully passed over cases, their certificate of statement of fact is unnecessary.
The 2 months, whether this can be.
3 months, 28 days.
For a week. For a week, we can. Present applicant is convicted for the offence punishable under section 306(498) into bracket C of the IPC for a period of 10 years. The present application is on the ground of the real navy passed on 26th of April 2023. Considering the death certificate issued by the competent authority, the applicant convict is to be enlarged on temporary bail for a period of a week from actual release. No further extension would be considered on any account. Rule made absolute direct service permit. Yes.
Part third met of the first session, syllabus 7, Dr. Abhishek Manu Singhal and its advocate. Yes, Napandre.
Just 3 or 4 points.
Yes.
3 points and one wind up. The first of those 3 points is the learning session scored at page 70 of volume 1. The point I just argued before lunch, that
Yes.
this evidence is not admissible without some degree of proving. All those things I gave a Russians. All this is put to him. He literally, with his great respect, rushes it aside in a very perfunctory paragraph at page 70.
Yes. Second part.
I'm grateful. As per the submission of Reserve Mr. Tolia, during the deposition of Raji, he was shown the video of the speech, and the CD was produced only to corroborate the version of witness. Not required. It transpired that the junction level trial court rightly relied upon evidence of Raji and bias. I believe that the discussion of admissibility, this is the entire case.
Yes.
I believe that the discussion of admissibility both of proof of electronic evidence would be required to be made at the time of final hearing. Moreover, the evidence, all of them will be made to final hearing. It is the prima facie nature which justified an interim enlargement on the ground of A, no sentence, and B, no conviction. And for that, your lordship is entitled to opine as an interim measure. Then the second point is another error which happens at page 82 or 7, 8, 10 pages later.
Yes.
The same order. That is the error. This is a gross error. A reliance is placed or holding against me by reference to your lordship's High Court judgment.
Yes.
In Manus Rika Bhai Kacharia's case.
Narayan Bhai Kachari.
Narayan Bhai, Rika Bhai Kacharia's case. And that is clearly at 82, starting, and then going on and concluding at 83. And it is enough, Malas, to note the 83 part, where the conclusion is, as envisaged by Honorable High Court Narabai. This is kindly mark the word Honorable High Court. Your Lordships of the High Court denied stay of conviction. That's the admitted position. Now, this is a serious error. I am not on the merits for this. The Supreme Court may be on 10 grounds, it may be partial, it may be because of a particular. But when you, as a learned sessions court, cite a Gujarat High Court judgment, you have to take care to see that it is not reversed. This judgment has been reversed admittedly by the Supreme Court. I will not go into the Supreme Court order. It's at 681, 684 of the volume 1 of the compilation. I'm sorry, not compilation, volume 1 of the
Judgment. The
Judgment.
This you also will not read, go into it, just go down the date.
Just one.
Date is
6, page number.
The judgment starts.
date 29 April 2016 is the date. The judgment starts at page 681.
Last.
And they hold on multiple grounds, but because it's also separately held on the ground at 683. So your lordship starts the judgment at 681.
Yes.
And your lordship, I'm not concerned with the merit, fellows. You can apply the High Court, Supreme Court, you have said this, your interpretation, but ultimately you are making an error because you are assuming that the Gujarat High Court is final. This is a reversal, fellows. See, fellows, the penultimate para at page 683.
Yes.
Under the circumstances, it appears to us, looking to the facts of the case, that adverse consequences will certainly follow, not only to the appellant, but also to his constituents, in case the conviction remains. The impact would virtually be irreparable. That's all that I am with. And they then reversed it in the last trial. The High Court said no, the Supreme Court said yes. The third point, fellows, on which I wish to end the merits. My lord has got it.
No, this one.
Now, this third one is Hardik Patel,
Yes.
who again got a rejection from the High Court. But it was reversed by the Supreme Court on 12th of April 2022.
I'm sorry. It was reversed by the Supreme Court on 12th of April 2022. They say only one line. The High Court ought to have suspended conviction, is what the Supreme Court says. They say it at page 2 of the order handed over. Rest is not relevant. They have leave granted. It's against, Lordship may take it. It's against a High Court order which said no stay of conviction. And then let's come to para 5. Para 5. Having regard to the facts and circumstances, we are of the view this is a fit case not only for suspension of sentence but also for suspension of conviction. The High Court, in our view, ought to have suspended the conviction as well. Well, it has brought me to the end. Yes, these are also serious offences, including 427 and 435. However, that brings to the end of the submission. I'm very grateful for the time here. I want to end by saying two things.
Yes.
At the end of the day, when a person has suffered conviction, the issue whether your lordship would stay conviction or not is largely between your lordships and the accused. It cannot in any remote manner concern a complainant.
So your main thirst is that they are not entitled to give any audience because
I will not put it as that strictly as audience.
Yes.
I'm saying see the larger picture of the weight your lordship will give to that audience.
Exactly.
I mean, I could put it as your lordship is saying, but I'll not go that far. Even if your lordship were to hear them, which I don't think your lordship should be in any elaborate way hearing them.
Yes.
The weight given to them has to be judged in this matrix. What is the matrix? That you, the complainant, have brought an attention of a crime. You have prosecuted it. You have got a conviction and you've got sentence. Is it not strange that you have not at all bothered about the sentence? Okay. But you are now bothered about the conviction stay because you want that no, sentence apart, punishment apart. This man must be disqualified. That is, if at all, in the realm of politics. It is in the realm of, well, it's ROPA. What concern do you have with ROPA? Well, who are you? You are a complainant. What is your concern? This can't be a legitimate concern. This can't be a legitimate concern. It can, of course, your lordship is administering 389. So lordship will administer 389 according to what is your lordship's understanding of the law. But a complainant says, I must be given dispositive or I must be given great weight because I don't want Mr. Singhvi to remain in parliament. That can't be a test for us. The second thing I want to end on is the single most important point of this is all such provisions, 389 in Miller's, your lordship's Arbitration Act, interim relief, civil suits, order 39, all of them have one basic thing. What is the balance of convenience? Now, I am ending on this, so let me summarize everything in bullets. The balance of convenience is a hodgepodge of these 5 or 6 obvious basic factors. And I cannot think, Wallace, of any case more weighted in favor of these factors than my case. I may be guilty of exaggeration, I may be wrong, but I'm putting it to your lordships. One, is it a serious offense? My answer, Wallace, is with great respect, the answer must be no. It is nothing in the nature of murder, rape, abduction, 5 years, 7 years, 10 years, life imprisonment. Number two, is it, without being a so-called serious case, a case of moral turpitude? That would be corruption, well, maybe some degrees of sexual offenses or other things. No, this is admittedly not that. Three, is it an anti-societal offense? Well, there may be, I can't think immediately, but there may be beyond these two categories, something which really creates, well, I would say, for example, creating enmity between sections. It may not have that much of 153A, etc., but it has a great societal impact where the interest is not only of Mr. Raval or me, but is of the state to maintain an order, law and order. Therefore, that also, I'm not that. Number four, is it a non-cognizable and bailable? Well, clearly. Number five, is it one which can only lead to simple imprisonment? It's only one out of 22 such. They have hundreds of offenses, only 22 such. Number six, these five are enough to stay conviction. But here, per se, there is a sixth ground. And I submit that per se ground is sufficient. Per se ground is, you are a legislator, yes. Will you lose your seat? Yes. Even while you don't lose your seat and before a new election is held, will you be able to attend parliament? No. Will you lose your seat after 3 to 6 months? Yes. Will the new man who comes be liable to be reversed and you reinstalled if you win your appeal in 9 months? Answer no. Malas, what better case then can be for getting Malas a stay of conviction when the consequences of non-stay of conviction are so drastic and more than drastic are so irreversible by the very nature. Malas, even in civil matters, your lordship has the capacity to compensate him by money, to reinstate me in my house. Here, Malas, the shot is fired, you can't get the bullet back, the horse has run, there's nothing, no other way of coming back, Malas. And Malas, lastly but not the least, if I don't get conviction stay, I am otherwise, apart from all these 7 consequences, I am Malas debarred from contesting for Malas a period which is Malas virtually semi-permanent in politics. They say a week is a long time in politics. We are talking of 8 years here. Therefore, Malas, I beseech my lords to consider this is not a serious crime. I have done no murder. It is given for the asking in even Malas every small case. In bigger cases, it is given with circumspection. As I do not deserve this, your lordship may consider it. I'm very deeply obliged for a patient hearing. Please.
Yes, Mr.
Please.
First you start, we call upon you.
Sir, I would like to respond firstly to the submission with regard to the locus in context of further submission that it is to attract the camera. My lords may kindly look to section 389, which had been applied for the purpose of staying the conviction. Yes. So this particular section falls in chapter 29.
Yes.
Now, so far as this revision application is concerned, it is in furtherance of the appeal filed by the petitioner.
Yes.
Appeal is under section 374. And in context of that particular submission, my lords may please look to section 386.
Yes.
Powers of the appellate court. After perusing such record and hearing the appellant or his pleader, if he appears, and the public prosecutor if he appears. Therefore, so far as locus of public prosecutor is concerned,
Yes.
regardless of it being a private complaint proceedings or a first information proceedings. Legislature, so far as this particular chapter where 389 has been there, permits public prosecutor a right of audience. Taking this issue to the section 389 itself, Honorable Court may please see the occurrence of the term may. Pending any appeal by convicted person, the appellate court may. Before emphasizing this term, kindly please see the proviso. In both the proviso, public prosecutor had been found to have locus so far as any application under 389 subsection 1 is concerned. In view of that, my submission is that public prosecutor has statutory right of audience so far as this particular chapter is concerned. Now, in context of section 389, where the term may had been used, that clearly signifies that it is certainly within the parameters of the different judgments which would be applicable and binding to the Honorable Court. But ultimately, the term may fully signifies that it is the discretion of the Honorable Court one. And at this stage, when the legislature had permitted the sentence of 2 years, the learned magistrate, in context of the gravity of the matter, had found that here is a fit case to award the punishment which is permissible under the law. It is not that punishment is beyond the capacity or competence. It is within the permissible limit. So, this is not the stage to agitate the aspect of quantum of sentence. This is the stage where Honorable Court may certainly look into very peripheral aspect of seriousness of the offence. But learned magistrate as well as the learned session judge had come to the conclusion, appreciating the material of investigation, that it is a serious offence in terms of the acts committed by the petitioner. Sir, therefore, I would very humbly submit that this is not a case where Honorable Court may exercise the discretion of staying the conviction. So far as other reliefs are concerned, learned magistrate initially and thereafter learned session judge has already considered. Therefore, sir, this is not a case where Honorable Court may consider staying of the.
What about the lacuna which is he has pointed out about that?
Sir, so far as those lacunas which my learned senior friend had placed before this Honorable Court, I would very precisely submit that those lacunas are, if at all found, this is not the stage to scrutiny or scrutinize those aspects. Say, for example, 202. All these aspects were to be agitated at an appropriate time. In this particular proceedings, agitating those issues probably is not warranted at this stage. Probably are not required to be considered at this stage. What is important is this, that learned magistrate, considering the evidence placed before him, had found that this is the fit case to convict a person or convict the petitioner for the maximum term which is available in the statute, and that he had done. Learned special judge, session judge, after considering submissions as well as material which was placed before him, had also approved that particular aspect. So the scope of the revision application probably is just to see and examine whether there is any perversity.
Is filed under which section? What is the scope of that?
So far as petition is concerned, it is filed if Honorable Court kindly permit me to point out from the memo of petition, it reads like this. Under section 397, read with section 401 of CRPC, against the judgment and order dated 20th April 23 below exhibit 5 in criminal appeal number so and so, so and so. So, my lords, so far as memo of application is
Now
concerned,
kindly read the provision 397 read with section 401.
my lords, I may do that. I may. Sir, here also, certainly I will be reading this particular provision. But again, the three term which has been used in the provision, correctness, legality and propriety.
I need that.
I may read. I may. The High Court or any session judge may call for and examine the record of any proceeding before any inferior court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality or propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. All magistrate, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior to the session judge for the purpose of this subsection and of section 398. The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings. If an application under this section has been made by any person either to the High Court or to the session judge, no further application by the same shall be entertained by the other of them. Now, one aspect which my learned senior friend probably had not put before the Honorable Court is whether the order which has been passed could be construed as a final order or it would be construed as an interlocutory. But keeping aside that aspect, I may read 401. In the case of any proceedings, the record of which has been called for by itself or which otherwise comes to its knowledge, and the High Court may, in its discretion, exercise any of the powers conferred on the Court of Appeal by section 386, 389, 390 and 391, or on a Court of Session by section 307, and when the judges composing the Court of Revision are equally divided in opinion, the case shall be disposed of in the manner provided by section 392. No order under this section shall be made to the prejudice of the accused or other person unless he has an opportunity of being heard, either personally or by pleader in his own defense. Nothing in this section shall be deemed to authorize High Court to convert a finding of acquittal into one of conviction. Where under the code an appeal lies and no appeal is brought, no proceedings by way of revision shall be entertained at the instance of party who could have appealed. Where under this code an appeal lies but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under the erroneous belief that no appeal lies thereto and that it is necessary in the interest of justice so to do, the High Court may treat the application for revision as a petition of appeal and deal with the same accordingly. Sir, another submission which my learned senior friend had placed for my Lord's consideration relates to about the offence committed by petitioner is a non-cognizable offence and bailable. But the moment judgment has been rendered, those aspects would pale into insignificance. Offence may be non-cognizable, may be bailable, but so far as applying provision of section 389 where the prayer is for staying of conviction, those consideration probably is not available to the petitioner. Sir, in that view of the matter, on my side, I am saying that what had been found by learned magistrate as well as learned session judge, that offense is serious considering the material of investigation. This is not the case where honorable court may kindly stay the conviction of the petitioner. These are my submission, my lords.
Yes. Yes, Mr. Nanavati, what do you have to say? First of all, maintainability and
I am on
status.
that only.
And
First of all,
status,
yes, my
what
state,
is you, yes.
yes, I'll
They
make
are
it.
seriously challenging your status.
Yes,
Once the conviction is recorded, therefore,
I am
now
on
you
that.
are-
I have played my role and it is over for me. Anyway, I'll make my submissions on that, but first, my lord, I will take, with my
Yes.
lord's permission, kindly see the memo of revision as couched
yes,
and presented before me. This revision, my lord, the top of it, on the first page itself,
yes.
under 397,
Hmm.
read with 401, against the judgment and order dated 20 April 2003, below application exhibit 5, in criminal appeal number 254 of 23 of the court of 8th additional sessions Judge Surat. So this is under 397, read with 401, criminal revision. Then my lord may kindly oblige me. Page number 5 of the memo. Paragraph 15. They have themselves, being conscious, devoted a paragraph about maintainability of the petition. This revision. And I may kindly be permitted to read. The present application under 397 is maintainable before these of the court in as much as impugn order passed by the learned sessions at Surat is not an interim or interlocutory order. It determines substantial rights of the applicant and his status in the eyes of law as a convict. Moreover, the impugn order sustains the disqualification that appellant has attracted with a section 8, subsection 3 of the Representation of People Act, is entitling him from his parliament membership and representing his constituency Wayanad, Kerala, from where the appellant was elected as Lok Sabha to the Lok Sabha by an overwhelming margin. Even otherwise, my lord, I am on this. Even otherwise, these applications challenging the impugn order shall be maintainable under inherent powers of the Honorable High Court under 482 of the Code, read with Articles 226, 227 of the Constitution of India, irrespective of nomenclature of the application preferred herein. So, my lord, they are not sure under which provision they are approaching these on the High Court in their respectful submission. The scope of revision, my lord, is well defined. Knowing fully well that scope, in the second breath, they are saying in this very memo petition in paragraph 5 that this can be under 482 as well, or as well as under 226, 227. In my respectful submission, they can't ride both the horses at a time simultaneously. Either it can be a revision only, or it can be a petition, special criminal application under 226, 227, read with 482, or only under 482. But this can't be the position that they themselves are not sure that which proceeding they are filing and which jurisdiction of the High Court they are invoking. Once that is the position in my respectful submission, they are just adding this sentence, nomenclature of the application, irrespective of the nomenclature of the application preferred herein. It cannot be irrespective of nomenclature because that will define the jurisdiction of the High Court. It cannot be. Nomenclature and the provision under which you are approaching High Court is the most relevant so far as the consideration and adjudication of that proceeding is concerned. If it is 226, it stands on one footing. If it is 227 supervisory jurisdiction, it stands on another footing. If it is invocation of inherent power of the High Court under 482, it stands on third footing. And if it is revisional jurisdiction of the High Court, then the scope is different. Therefore,
I would respectfully submit that this petition filed as it is not maintainable. Anyway, my lord, I was to submit in the opening, but the query came therefore from the state that in fact it requires at least a reply from our side.
It is a revision application more so. It is based on the
No,
records
various
which is
fact-
already
Now, from the memo,
before the court.
I can demonstratively point out, as I have pointed out these aspects. Various factual aspects are stated, which is not at least in conformity with the record as it exists. Record is also not called for as under the revision, either at their instance or at the High Court on its own suo motu, has to call for the record and proceedings in revision. It can't be decided in absence of the record and proceedings. If I have to point out something, that whatever is produced, I don't doubt the genuineness of it. But at the same time, as the translated copies are provided, original depositions are recorded in Gujarati. It may change the meaning sometime. Translator may commit mistake also. I am not attributing any further thing. So first of all, at least RNP, if at all, if it is revision, is required to be called. If it is not revision, and 226 petition, then reply is required in my humble submission. If it is 482, again reply will be required. So in this situation, at least I am not clear, or they may make their breath clear that we are invoking this jurisdiction. If it is purely they are invoking revisional jurisdiction, then on the basis of the material.
Then if you want to file your affidavit, you file Tuesday.
Lordship.
I am not granting any
No,
further.
I will not take any further.
I have to complete these proceedings. That's all.
My lord, Tuesday I will file. I'll give them copy if
In
possible by
advance.
Monday,
Yes,
late evening.
no longer time. So now we have sufficiently invested.
Yes,
time.
lot of
We
time.
have to conclude.
I am obliged.
That's all.
Can I just take 5 minutes on this primary objection?
Yes,
Just 5 minutes.
yes.
Okay.
But it's, since your lordship will be rising, I don't want your lordship to rise under a misconception
No.
propounded by my learned friends.
Yes.
Just now, apparently, Wallace, they have not read the direct Supreme Court judgments. We have just been accused of not knowing whether we are fish or fowl, whether we are duck or drake, because we don't know whether we are 397 or whether we are 482 or whether we are 226. Now let's just note these two answers directly covered by our lordships. We have taken care of. Obviously, it is not for me to get up and say, look, please note, my lords, that I am maintainable. I can only reply and rejoin that after he raises the objection. And I was certainly not here, Malus, to give him an idea to raise an objection or to invite one. Now, therefore, Malus, what is the answer to this? Number one, what is this order? This order is a final order, finally rejecting my stay of conviction. Does this order leave anything? Well, your lordship will just read the judgment. Trappings of finality. Your lordship has got this final interim interlocutory age old, 100, 200 years old. In the civil side, your lordship had the Gujarat case. It started from Gujarat. Shah Babulal Khimji, which very famous case went into Supreme Court. Finality is, first, I'm giving you 4 answers, clearly covering it. Is the order under appeal final where the subject it decides? Answer is yes. I have nothing else to do by way of interlocutory approach in that order. In the course of a proceeding, there are many issues which will not finally dispose of the main appeal, but will raise and decide issues which in the course of the appeal are final in themselves.
The final effect of and the final resultant effect of that it is to
Of
be-
this order is the first test.
Yes.
Is it final? Clearly, Willis, the conviction which is my mainstay, without which I can't survive on disqualification, without which I can't survive on fighting elections, without which I cannot do anything, is finally decided. It's not interimly decided. It is not interlocutory decided. I have nowhere else to go. Second, directly this issue is decided in Madhulime. Turn to that, Willis.
That's page 192 of the blue file.
Now, the Madhulime is 1977, 4 SCC, 551, 3 learned judges separately held 2 points. And I will deal with the second point first, because it disposes of the objection completely. Supreme Court has decided this conclusively in a criminal matter 50 years ago or 40 years ago. And we are told, brothers, that this is not the law. Note here, brothers, it was a worse case. They said, Mr. Madhulime himself said that this trial is bad because the sanction is not properly got, and 1 or 2 other things in the course of a trial. He went to the court. The court held that this is so and so. He went in revision. The revisional court said it is interlocutory, and it worked. Supreme Court reversed. Now see that, brothers, para 12 and 13. And I'm sorry, very important, defamation case. Defamation case. Directly relevant on all fours, even on facts and context. Ordinarily and generally, the most exhaustive dealing 40 years ago, brothers. This point doesn't arise now. Doesn't survive anymore. Ordinarily and generally, the expression the expression interlocutory order has been understood and taken to mean as a converse of the term final order. In volume so and so of Halsbury, a judgment or order may be final for one purpose and interlocutory for another, or final as to part and interlocutory as to part. The meaning of the 2 words must therefore be considered separately in relation to the particular purpose for which it is required. In general, a judgment or order which determines the principal matter in question is termed final. The principal, this is the point, brothers. What is the principal matter? Either I have a conviction of stay, a stay of conviction, or I don't have. That's final. An order which does not, I mean the next quotation, brothers. An order which does not deal with the final rights of the parties, but either is made before judgment or gives no final decision on the matter in dispute, but is merely a matter of procedure, or is made after judgment and merely directs how the declaration of right is already given are to be worked out, is termed interlocutory. I'll skip all this, brothers. A Kupuswami, they refer to, brothers, Salomon, the old judgment of the House of Lords. And just turn the page, brothers, to 199. Applying the test, almost on fact similar to the ones in the instant case, it was held that the order and revision passed by the High Court, at that time there was no bar like 397.2, was not a final order within the meaning of 205. It is to be noticed that the test laid down was that if the objection of the accused succeeded, the proceeding could not have ended, but not vice versa. Now, may I skip it with your lordship permission? There is nothing much relevant, and start from about 7 lines below. If it were so, it will render almost nugatory the revisional power of the Sessions Court or the High Court conferred on it by 397. On such a strict interpretation, only those orders would be revisable which are orders passed on the final determination of the action, but are not appealable under Chapter 29. This does not seem to be the intention of the legislature when it retained the revisional power of the High Court. In what cases then the High Court will examine the legality or propriety of an order or the legality of any proceeding of an inferior criminal court? Is it circumscribed to examine only such proceeding which is brought for its examination after the final decision and wherein no appeal lies? Such cases will be very few and far between. Then they cite Chamarbogwala, etc. and see after that. On the other hand,
Last 4 lines.
I'm grateful. I'm very grateful. But just before that, 2 lines also fell after. On the other hand, the legislature kept intact the revisional power of the High Court. On the other hand, put a bar on the exercise of that power in relation to any interlocutory. Then the last 4 lines, I'll jump to that. Yes. By a rule of harmonious construction, we think that the bar in 397.2 is not meant to be attracted to such kinds of intermediate orders. They are intermediate because they don't decide the trial. You don't convict me or you don't acquit me. But they are still final to what they decide. They may not be final orders for the purposes, yet it will not be correct to characterize them as merely interlocutory orders. It is neither advisable nor possible, because this whole para is very important, to make a catalogue of orders to demonstrate which kinds of orders will be merely, purely or simply interlocutory, exhaustive lists, etc. One thing, Malal, before I leave this, is para 2. No, the beginning of the facts, para 5. Look at what he appealed against, para 5. This is important. The defamation case is very important. I forgot to mention it. My learned friend rightly reminded your lordships. Defamation is what is mentioned in para 2, fourth line of para 2.
Yes.
Fourth line of para 2, defamation case. Now come to para 5. The sessions judge rejected all these contentions. What are the contentions? But I'm sorry, para 4. Just see 4. The appellant raised 3 contentions. Even assuming the allegations made against Antulya were defamatory, they were not in respect of his conduct in the discharge of his public functions, and hence so and so. The sanction given was bad. Third, Chief Secretary did not apply. Purely, in that sense, interlocutory, because they don't decide the trial finally. But, 5, the sessions judge rejected all these contentions. The appellant challenged the order of the session and the High Court revision. And then it came up to the Supreme Court. Now, the second point, my learned friend, this part is clear, it is maintainable, and the last para, as my lord says, is directly on point. 3 judges 40 years ago. It has stood the test of time. My learned friend added one thing more, which I'll end on this. He said, this appellant, this revision petitioner today, me, does not know whether he should enter like a 482 petitioner, or as a 397, or as a 226, or as a 227. The first part of this judgment has something very, very much more important, which my learned friends should be advised about. It says, now I am anyway in revision, and the revision is maintainable. I am finished on that. I am not repeating. Suppose I had come in 482, or I had come in a non-maintainable 397. In both those cases, your lordships has the power to convert it and hear it like 482, is what this court is saying. So instead of making me not knowing whether I am fish or fowl, it says that the court can decide, I will treat you like a fowl or a fish, but I will do justice. That para is important. Para 10. That's the first part. In this case, it says your 397 is maintainable. Suppose it was not maintainable, I will decide you the 482. 10. Suppose there is no identity crisis, which I will have or lordships will have, in the event a lordship wants to treat me as a 482. Just see the lower part. Actually, the last 5-6 lines will be enough. Whereas the whole para is important. I will not read. Lordship will note the whole para. But just see the last 5 lines now. The label of the petition filed by an agreed party is immaterial.
Unfortunately, I am having the underline mark.
Oh,
Which you have.
Oh, I see.
For your purpose, you have underlined that line.
Sorry. I'm sorry. I'm sorry. So therefore, anyway, the last 5 lines, the label is irrelevant. The High Court can examine the matter in appropriate case and the inherent powers. The present case undoubtedly falls for excise. In the event, there's no problem. The second part, para 12 and 13 says you're okay. But in the event they are not okay, your lordships can do it. Well, it's
in the last part also you have marked the certain portion of that.
Well, I'm very
is also important.
This is a
But it is relevant.
I did not know what copy was handed over to your lordship. I'm sorry. Sorry. Can we replace it, Malas?
There is no.
Well, there are some judges we have in Delhi High Court whose instructions, practice direction is issued to say that you must give me written submission of 3 pages. But with that, you must give me case law. And there is a learned judge retired just now. It's a very useful practice. The judgments must all be put in 2 or 3 color codes. It's prescribed in practice. One is blue, one is red, and leave the other one for me to put. The judge will put. That is, well as those portions you are relying upon. And in case you are a respondent, those portions with the other side is already relied upon. And then the judge will decide. So he loves well as marked copies being given.
Yes, we will also love.
No, that was not the intention. That was not the intention, though. Well, it's only one thing. Give me a minute to do one thing.
Yes.
Well, it's, I was only wondering, does your lordship really, well, in a matter with the entire record here, reply, well, the record is this, what record, what reply can anybody file? He
I have
can't
not
change.
called for records.
No. I'm saying, well, his reply cannot change anything.
Because
Because
he may, whatever he wants to point out, he may point out. So
Right.
there is nothing remain in the, we
I see.
conclude the part on Tuesday, that's all.
The hearing,
I may file on
Everything, hearing and everything would be over on Tuesday, no further time.
Monday evening, right, sir?
very well.
Well, I may file even relevant documents if at all we are relying,
Whatever-
without any reply.
whatever you
or
rely,
pleadings
Just
and
if
all.
you want to file, you
Yes,
file.
by Monday evening, we will serve the
Yes.
copy, late,
So on
by 8
Tuesday.
PM also.
On Tuesday, it will be
Tuesday,
over.
yes. Oh, yes.
Because after 5th, I am not available in India. I have to leave. And before that.
So we also, Manas, we wanted a
We will be in a
judgment
different
this way,
light.
that way, before that. Manas, last point was 386, that's the one point we made,
Yes.
386, 2 minutes. I forgot.
Yes,
I forgot to answer the learned purple. Manas, the 386 is a red herring. Just see 378.4.
Yes.
Sorry, not 378? Yeah, 378.4.
378.4, yes.
My learned friend can appeal or challenge only when I am acquitted. Here he is challenging when I am convicted.
I am not challenging it.
No, not he. They will accept the interpretation. I'm not on the, I'm saying, he's the
Yes.
prosecutor's argument. I'm not on the actual, I'm saying the interpretation. He says, I always have a right to speak. I have a right to audience on this. The right to audience in 378 bracket 4, your lordship gives to him because he walks away scot-free. He acquits and he walks out of the room. So lordship says if he's walking away scot-free, please give a right to the PP.
Only to the complainant.
Not PP, complainant to object. Now let us suppose the right is given only to the complainant to object, even when he's walking away scot-free. Then how can there be a right when he's convicted? Well, let's kindly appreciate what I'm
Yes,
saying.
yes. Certainly.
Your lordship's policy is to not let me go scot-free without a challenge by the complainant. The policy can't be that when I'm being convicted, somebody other than the complainant will again have a right in a bilateral offense, in a locus offense. So it's contrary to what 386 doesn't say anything of this kind.
His contention is also dealt with.
Would your lordship like to have it at 11 or 2:30 so that will not be?
If you
No,
come-
subject to your lordship,
Yes,
will not be.
because now we are having only 10 to 11 matters.
Okay.
We would
So after
prefer
that, we
2:30.
immediately
I don't
start
mind, I
this.
don't mind.
If your lordships can
You're
consider
coming from-
2:30.
2:30, I
I
think.
mean afternoon session.
Yes, sir.
Tuesday afternoon session?
Second, yes,
Absolutely.
second half.
Obliged, very deeply
Second.
obliged, very deeply obliged. Very deeply obliged.
Obliged, please.
The learned council concluded their arguments. But at the same time, the learned council, Mr. Nanavati, appearing on behalf of the original complainant, wants to produce certain documents. So, in the interest of justice, the document is to be produced on record on or before Tuesday. Yes, on or before Tuesday, and the copy is to be served in advance to the other side. That is the petitioner.
Yes, yes, I have said this.
That is by Monday.
I have stated this.
That's all right, no problem.
I'll come
I'm
to your
observing all
home.
these things.
No, nothing, no problem, no problem.
When I stated it is
Yes,
stated.
it is to be served on or before.
नमस्कार, मैं एडवोकेट वीके आनंद आपके लिए और भी ऐसे अच्छे कंटेंट और न्यूज़ लाता रहूँगा। हमसे बने रहने के लिए लाइक करें, शेयर करें, सब्सक्राइब करें और हाँ, फॉलो करना ना भूलें।